The Pennsylvania Mock Trial Competition is being brought to you by the Pennsylvania Bar Association, which strives to promote justice, professional excellence, and respect for the law, improve public understanding of the legal system, and provide access to legal services for all citizens. And by the Pennsylvania Bar Foundation, representing the commitment of Pennsylvania lawyers to promote youth justice education and to ensure equal access to the law for Pennsylvania's most vulnerable.
Good morning.
Good morning.
On behalf of the Pennsylvania Bar Association, welcome to the 2016 Pennsylvania Statewide High School Mock Trial State Finals. We have a few thank yous. First of all, I would like to thank our Mock Trial Executive Committee, my co-chair, John Courthouse, Jonathan Grode, Paul Kaufman, Jane Meyer, Dave Travaskis, and the two PBA staff who have helped set this all up, Maria Engels and Janelle Klein. We would also like to thank the many presiding judges, scoring judges, bailiffs, and timekeepers who have helped throughout this competition. We would like to thank the district and regional coordinators who have run the competitions at the local level and got the team of 14 teams here this weekend. We would also like to thank the county bar associations who have helped the coordinators throughout these past couple months. We would give a special thank you to the parents of the talented and dedicated students participating in this year's competition. We would like to thank the teachers, the attorney coaches, and the parents of the students in helping the teams today. A special thank you to the Dauphin County Courthouse, who has each year allowed us to use the courthouse in these competitions, and their staff and personnel. With that said, I will introduce John Grode, who is going to give the case summary.
Thank you. On behalf of myself, the rest of the case authors, Paul, John, and Talia, who couldn't be with us here today, I'm honored to read this melodramatic summary of today's proceedings. An environmentalist, a drone, an injury. On September 27, 2014, a young man named Stephen Yeager was hunting from horseback at the Natural Habitat Preserve, an environmental sanctuary in central Pennsylvania. As he chased his prey, a helicopter drone flown by the preserve's director flew too close to Yeager. Yeager's horse panicked, throwing Yeager from his horse and causing severe injuries. The preserve says that this was an accident, a negligent act by its director, and thus its insurance policy for the drone should cover the costs of the preserve's legal settlement with Yeager. Its insurance company argues otherwise, claiming that the drone was modified in violation of the insurance rider at the time of its flight, voiding the company's obligations to indemnify the preserve, and that the preserve's director was intentionally using the drone to scare Yeager, taking the actions outside of its policy scope. On this question turns millions of dollars, and perhaps the preserve's existence. Today, the jury will decide.
We're very fortunate today to have an established panel of scoring judges, who I will let introduce themselves.
And I'm Assistant Counsel for the Department of Education.
Elise Rogers, attorney in private practice.
Good morning, I'm Grant Keener. I'm an attorney here in Pennsylvania. I serve as Dean of Admissions at the University of Florida's Law School, and I'm on the board of the American Mock Trial Association.
Good morning, I'm Jim Sheehan. I'm a retired civil litigator, corporate counsel, and government lawyer.
Good morning, I'm Chester Corse. I'm the past president of the Pennsylvania Bar Institute, the educational arm of the Pennsylvania Bar Association. I'm a practicing attorney here in Pennsylvania.
Marion Laughing Ferry. I was in private practice until the end of last year. I am currently on the board of directors of the Pennsylvania Bar Foundation, which funds this competition.
Good morning. I'm Sam Milkus, the Executive Director of the Pennsylvania Legal Aid Network, the statewide system of civil legal aid for low-income Pennsylvanians.
Good morning. I'm Justin Baer. I'm the Chair of the Young Lawyers Division of the Pennsylvania Bar Association, and I practice civil litigation at Kane, Pugh, Noel, Troy, and Kramer.
Good morning, everyone. My name is Bill Pugh, and I am the President of the Pennsylvania Bar Association.
And I will also be sitting on the scoring judge panel today. My name is Tracy Noggle. I am the co-chair of the statewide high school mock trial competition. I am also a partner with Stokenhoff, Kremansky, and Noggle.
I will also be serving on the jury today. My name is Jonathan Koltash. I'm the other co-chair of the mock trial competition, and I am senior counsel for the Pennsylvania Department of Health. Before we bring the jury out, or bring the judge out, I turn it over to our bailiff here today. I'm going to give just a brief overview of who our presiding officer will be today, a little bit of biographical information. Our presiding judge today will be James J. Ross, elected to the Court of Common Pleas for Beaver County in 2013. Prior to that, he worked for 20 years for the firm of Bowers, Ross, and Fawcett. He served as United States Attorney in the Western District from 1984 to 1991, and during that time, or a piece of that time, he was the chief of the Erie Division. He's a graduate of the Ohio Northern School of Law. He has a master's in public administration from the University of Tennessee and a bachelor's degree from Baldwin Wallace College in Ohio. But more importantly, he's been a dedicated volunteer of this program for over 25 years. We're going to take the jury box. We're going to turn it over to the bailiff to begin the proceedings.
All rise. The United States District Court for the Middle District of Pennsylvania is now in session. The Honorable James J. Ross presiding.
Please be seated. Good morning, everyone. It is truly my privilege and honor to preside over today's proceedings. I would like to strongly congratulate the two teams for making it to the state final. This is a wonderful program, and the fact that you've made it here is truly an honor for you. I would encourage everyone to remember that even though this is a competitive event, it is something that is intended to educate not only the public to what young people can do and what our Bar Association does for the community, but also for you to participate in a meaningful program that will help you for the rest of your lives. Above all else today, please have fun. At this time, I call the case of Lilienthal Insurance Incorporated versus Natural Habitat Preserve. Before we begin the proceedings today, I would just like to encourage everyone to remember to turn off any cell phones. We don't want anything to distract the participants. Also, please, if you can, remain in the courtroom. We don't want people leaving frequently so that again distracts from the proceedings. At this time, I would ask the bailiff to swear the witnesses in connection with today's proceedings, and if all of the witnesses would please rise and raise their right hands.
Do you swear or affirm that the testimony you are about to give in the matter now hearing will be the truth, the whole truth, and nothing but the truth? I do. Please be seated. The witnesses have been sworn, Your Honor.
Thank you very much. Is there anything that counsel would like to take up with the court in the way of pretrial matters before we begin?
Yes, Your Honor. First, the plaintiff asks that all objection arguments be held constructively outside of the jury.
We're not going to, the rules of mock trial do not permit sidebars in connection with these proceedings, so that we will have the objections in open court, and I will permit each side to argue and then rule.
Yes, Your Honor.
Okay?
Next, the plaintiff asks your preference for moving about the well and asking to approach opposing counsel, the witness, and the bench.
I have no real strict rules. The only thing I ask you to do is to be professional. Do not invade the witness's space. I'm not really concerned that you ask my permission to approach a witness.
Yes, Your Honor. Next, the plaintiff invokes mock trial rule of competition, Rule 4.7, which states that non-party witnesses are constructively sequestered. The plaintiff has designated Ms. Charlie Yeager as its party representative today, and therefore she will not be constructively sequestered, Your Honor.
Okay, I understand your request, but that's really technically not possible because we have witnesses in the courtroom. Everybody knows the material, so I'm not going to ask any witnesses to leave.
Constructively sequestered, Your Honor.
Okay, I understand.
Yes, Your Honor.
Anything else?
And finally, may the plaintiff please state its appearances for the court?
I'm sorry, I didn't hear what you said.
May the plaintiff please state its appearances for the court?
You may. We were going to do that in a minute. I just wanted to know if there were pretrial matters. I'm going to allow you to do that. Is there anything from the defense in the way of pretrial matters?
Not at this time, Your Honor. Thank you.
Thank you. Okay, with that, I don't want any teams mentioned or the identity of teams, but what I would like you to do is just identify yourself for the jury and your role you will play in the case.
Yes, Your Honor.
You may.
Good morning. My name is Samarth Desai, and today I will be performing the opening statement, the direct examination of Ms. Val Coleman, and the cross-examination of Captain Emery Wagstaff. I'm joined today by my co-counsel.
Good morning, Your Honor. My name is Emily Leroy, and today I'll be performing the direct examination of Ms. Charlie Yeager, as well as the cross-examination of Ms. Quincy Wright.
Good morning, Your Honor. My name is Sarah Edgar, and today I will be performing the direct examination of Finley Lindbergh, the cross-examination of Stacey Earhart, as well as the closing arguments for today's case.
Thank you. You may be seated, and your witnesses.
Yes, Your Honor.
Good morning, Your Honor. My name is Paige Allen, and I am Charlie Yeager.
Good morning, Your Honor. My name is Avery Cunningham, and I am Finley Lindbergh.
Good morning, Your Honor. My name is Kobe Wise, and I am Dallas Coleman.
Your Honor, today we're also joined by our lovely timekeeper.
Good morning, Your Honor. My name is Lina Chori-Jam, and I will be one of the timekeepers for today's trial.
Thank you all. You may be seated. The defense, you may identify yourselves.
Good morning, Your Honor. Ladies and gentlemen of the jury, my name is Thomas Belsterling. I'll be presenting the opening statements, direct examining Stacey Earhart, and doing the cross-examination of Ms. Charlie Yeager.
Good morning, Your Honor, members of the jury. My name is Austin Kuntz, and I will be conducting the closing arguments, the direct examination of Captain Emery Wagstaff, and the cross-examination of Ms. Val Coleman.
Thank you.
Good morning. My name is Anna Marie Lover. I will be conducting the cross-examination of Finley Lindbergh and the direct examination of Quincy Wright. These are our witnesses.
Good morning. My name is Grant Burnett, and I am Quincy Wright.
Good morning, Your Honor, ladies and gentlemen of the jury. My name is Sarah Belsterling, and I am Stacey Earhart. I hope you enjoy our trial. Good morning, Your Honor, ladies and gentlemen of the jury. My name is Megan Gannon, and I am Captain Emery Wagstaff. Thank you all for your time today.
And your timekeeper?
Good morning. My name is Emily Chinchilla, and I am the timekeeper.
Thank you. Now that the preliminary matters have been concluded, I believe we're ready to begin opening statements. Is the plaintiff ready to give its opening statement?
Yes, Your Honor.
You may proceed.
With great power comes great responsibility. May it please the court, opposing counsel, members of the jury. Today's case is all about a disputed insurance contract that allowed the defendant, the Natural Habitat Preserve, the right to fly a drone over their property. But members of the jury, with the power of flying that drone came the responsibility of abiding by the terms of the insurance contract, a responsibility that the defendant ignored. Now, in 2012, the Natural Habitat Preserve Conservation hired Stacey Earhart, an environmentalist with a bold plan to restore the preserve's land. But members of the jury, Stacey Earhart's plan had one obstacle: Stephen Yeager, the youngest member of the local Wissowee Hunt Club, who set Miss Earhart back weeks of work and thousands of dollars by entering restricted areas of the preserve. Now, at first, Miss Earhart confronted Stephen and threatened him. But then, you'll learn that she took it one step too far. You'll learn that she bought a drone, which she used to monitor Stephen during hunts. But on September 27, 2014, Stacey Earhart intentionally used that drone to scare Stephen Yeager. The horse that he was riding got spooked and threw him off. Stephen suffered brain damage and is now paralyzed from the waist down. Members of the jury, because of what Stacey Earhart did, Stephen Yeager will never be able to walk again. He'll never be able to have children. Now, it's important for you to understand that no matter what the outcome of the trial today, Stephen's going to get taken care of. His case has already reached a settlement. Today's case is about who pays that settlement. And we, the plaintiff, represent Lilienthal, the preserve's insurance company. And as plaintiff, we bear the burden of proving our case by preponderance of the evidence, meaning more likely than not. Not only do we accept this burden, but members of the jury, we embrace it. Now, in the United States, contract law is sacred. Contracts are binding, and Lilienthal's contract was crystal clear. Intentional acts would not be covered. The drone couldn't be materially modified, and the drone couldn't weigh over 55 pounds. And members of the jury, if the preserve violated even one term of that contract, then they would have to pay their own damages. Today, we'll prove that Stacey Earhart did violate those terms, that she had intent, made material modifications, and added excess weight. First, Stacey Earhart had intent. You'll hear that Stacey Earhart had 6 different altercations with Stephen Yeager in less than 2 years. And you'll learn that even after Stephen wrote a letter to Lilienthal saying that he was scared of the drone, Stacey flew that drone near him 2 more times, with the second time resulting in his paralysis. Second, Stacey Earhart made material modifications. Now, this court has defined a material modification as one that could have changed the drone's airworthiness, or the way that the drone flies. Expert witness Val Coleman will testify that Ms. Earhart made several material modifications, including adding a heavier camera and a whistle. And Stacey Earhart herself will admit that she added fins to the drone to change the way that it flew. And finally, Stacey Earhart added excess weight. Expert witness Captain Wagstaff will take the stand and tell you that in his expert opinion, based on an industry standard accident reconstruction model, he was able to calculate that the drone weighed over 55 pounds on the day in question after recovering 45 pounds of wreckage at the crash site. Now, members of the jury, Lilienthal granted the preserve the power to use technology to make the world a better place. But that power came with responsibility, with restrictions, with a contract, with terms that had to be followed. Stacey Earhart violated this contract. She didn't hold up her end of the bargain. She had intent, made material modifications, and added excess weight. And that is why at the end of the trial, my co-counsel, Sarah Edgar, will come before you and ask you to find in favor of the plaintiff. Thank you all very much.
Just for those in attendance, there will be some brief pauses in between because I have to allow the jury the opportunity to mark down some scores. Is the defense ready to give its closing argument?
Yes, Your Honor.
You may proceed.
May it please the court? Opposing counsel, ladies and gentlemen of the jury, as you've already heard, on September 27th, 2014, Stacey Earhart was piloting her drone above the Natural Habitat Preserve. Now, we as the defense will attempt to show that Stacey Earhart was only trying to prove that Stephen Yeager was damaging the preserve's land by riding into this recently replanted and newly restricted section of the preserve. It's crucial for you to understand as members of the jury that Stephen Yeager, by riding into this restricted section, was violating a contract between the Natural Habitat Preserve and the local hunt club. We will show that Stacey Earhart was only trying to acquire video evidence of this violation when a gust of wind caused her to lose control, which resulted in the accident that led to Stephen Yeager's injuries. We're here today because Lilienthal Insurance is refusing to pay the $2.5 million settlement claim for Stephen Yeager's injuries. Today, you will hear that the Natural Habitat Preserve purchased an insurance policy from Lilienthal Insurance in order to cover their unmanned aerial system, or otherwise known as a drone. Now, throughout the course of today's proceedings, the plaintiff will attempt to show that the Natural Habitat Preserve violated their insurance policy from Lilienthal. And the reason they'll attempt to do this is because the plaintiff has the burden of proof in today's case, meaning they must prove to you by a preponderance of the evidence, or in other words, that it is more likely than not that Stacey Earhart either 1, made material modifications that significantly affected the way the drone flew, or 2, flew this drone in a way that was not consistent with the insurance policy. The first claim the plaintiff will make to you is that Stacey Earhart made material modifications. The court has already defined that a material modification is only a modification that would significantly affect the way the drone flies. And the court has further defined that any slight or unimportant change cannot be considered a material one. Stacey Earhart will testify herself before you today that at no point in time did she notice a change in the way the drone flew. The second claim that the plaintiff will attempt to make is that Stacey Earhart was not flying this drone for educational or conservational purposes, which was provided for under the insurance policy. However, we as the defense will show you that on September 27th, Stacey Earhart was flying this drone in the regular course of preserve business, and more importantly, was flying this drone with the specific intent of protecting her conservational effort in the restricted section, a term that was provided for in the insurance policy. Ladies and gentlemen, insurance companies can offer a great benefit to society. They indemnify policyholders in the face of a catastrophe, much like the one that occurred at the Natural Habitat Preserve. However, the only way that an insurance company can remain profitable is if they can collect a premium from a client and not have to pay for a claim. Therefore, it would greatly benefit an insurance company to offer their clients vague policies so that in the face of a claim, they can interpret those policies for their own benefit. We will show you that Lilienthal Insurance is doing just that today. We will show through testimony by Quincy Wright and Stacey Earhart that whenever they tried to get clarification about the policy that was granted to them by Lilienthal, no written clarification was offered. And more importantly, you will hear that Lilienthal Insurance allowed Stacey Earhart and allowed the Natural Habitat Preserve to believe that their actions with the drone were appropriate and covered under the insurance policy. If we can show that Stacey Earhart's actions on September 27th were educational or conservational, then we have proven that her actions were merely negligent, and the insurance contract covers negligent actions. And therefore, at the end of today's proceedings, my co-counsel, Austin Kuntz, will stand before you and ask that you find Lilienthal Insurance responsible to pay for the claim regarding Stephen Yeager's injuries. Thank you.
Is plaintiff prepared to call its first witness?
Yes, Your Honor. The plaintiff calls Ms. Charlie Yeager to the stand.
Please come forward. You've already been sworn. Make sure you speak into the microphone so your voice is picked up, and you may proceed, counsel.
Yes, Your Honor. Could you please introduce yourself to the court? Hello, I'm Charlie Yeager. What do you do for a living, Miss Yeager? Well, I've been the senior investigator for Lilienthal Insurance for about 6 years now. How did you become involved in insurance investigation? Well, I was with the state police, and then I served as deputy chief in charge of criminal investigation for the Wissahickon Police Department. After 31 years on the force, I retired and made the move to Lilienthal. And what do you do at Lilienthal as their senior investigator? As senior investigator, I investigate all insurance applications and claims from the Pocono region. Now, Ms. Yeager, did you render an opinion in today's case? I did. Did you render this opinion to a reasonable degree of scientific certainty? Of course. What materials did you review in preparation for today's case? I reviewed the rider Lilienthal issued. I conducted interviews with both Stacey Earhart and Finley Lindbergh. I downloaded the web history from Earhart's computer, and I investigated the drone wreckage and recovered video footage. Did you employ methods that are customary to your field? Of course. Your Honor, at this time, the plaintiff moves to enter Ms. Charlie Yeager as an expert in insurance investigation with professional experience in criminal investigation.
Defense?
Yes, Your Honor. I object under Rule of Competition 4.9. Each party is granted or proffered an expert witness. In this case, the plaintiff's expert witness is Val Coleman. Val Coleman, in preparation for this case, read all witness statements and all exhibits. Ms. Yeager has not done so and has not provided that information for the court. Additionally, there's been not enough educational background to qualify her as an expert in insurance investigation, which is what she'd be testifying today. She does have a degree in criminal justice, and she did work as a criminal investigator. However, her experience in insurance investigator, I believe, is lacking.
Your Honor, I'll take those one at a time. First, pursuant to Rule 4.9, there are 2 expert witnesses stipulated in today's case. However, if counsel can provide proper foundation and about another witness, then they can be entered as an expert as well, as long as they have the proper foundation and the proper expertise. Now, in terms of whether or not this witness has the proper foundation to be entered as an expert in insurance investigation, pursuant to Rule 702, a lay witness may be entered as an expert in a specific topic as long as they show sufficient education, training, knowledge, skill, or experience. This witness testified that she is the senior investigator at Lilienthal Insurance and has been so for the past 6 years. That meets the experience requirement. Furthermore, this witness testified that she investigates every single insurance application and claim in the Pocono region and has done for the past 6 years. This meets the skill as well as training requirement, Your Honor.
Any response?
Yes, Your Honor. Once again, the educational requirement has not been met. And the reason that Ms. Yeager has conducted the investigations for Lilienthal in the Pocono region in the past 6 years is because she is the only person who works for Lilienthal in that region. So I don't believe the simple fact that she has worked for Lilienthal Insurance, a singular insurance company, for 6 years would qualify her to testify in court, as the proper foundation to show that she's qualified and that she has testified in court before has not been laid, and the proper foundation that she is educated in this subject has not been laid.
Your Honor, if I may respond, it is important to clarify that education is not the only way that an expert may be entered. They can also be entered as under skill, experience, training, or knowledge. Education is simply one of the options, and this witness has clearly testified that she meets the experience, skill, and training requirement. Opposing counsel objection goes to weight versus admissibility.
At this time, I am going to sustain the objection for this reason. The witness is not designated as an expert in the materials. Moreover, this witness conducted an investigation and is a fact witness under the materials. To the extent that the witness may be able to give expert opinions lay opinions based upon perception, under Rule 701, if the proper foundation is laid, we'll be able to do so, but will not be designated as an expert for purposes of these proceedings.
Yes,
you may
sir.
proceed with the question.
Yes, Your Honor.
How are you involved in today's case? Well, in February of 2014, I was sent to NHP to determine whether Lilienthal should issue them a rider. And could you please tell the jury what a rider is? A rider is a provision of an insurance policy purchased separately in order to provide additional benefits at an additional cost, in this case to cover a drone. And how did you go about determining whether NHP should be issued a rider? I set up a meeting with Stacey Earhart, the preserve manager, to determine why NHP felt they needed the drone and what they planned on using it for. And how did this meeting seem to go? Well, I asked Earhart some questions to make sure she'd be using the power she'd been given in a responsible way, but Earhart seemed to get very defensive. What do you mean she seemed defensive? Well, instead of answering my questions, Earhart started questioning me. Classic tactic I've seen in suspects for years. Divert attention. She accused me of being biased because of my relation to Stephen Yeager. How are you related to Stephen Yeager? He's my godson. And did you let that affect your investigation in today's case? Of course not. I've been involved with law enforcement and investigation for close to 4 decades now. I would never allow some silly feud between a 17-year-old member of my family and Ms. Earhart to affect my investigation. What feud are you referring to? It started in 2013 when Yeager went on to one of Earhart's restricted areas. I also know the preserve's fire tower was vandalized. It was only a week after this vandalism that Earhart first made the request to purchase a drone, and it was the timing of this request that concerned me. So what did you do? Well, I did my job. I gathered the facts and reported them truly and fully to Lilienthal. And what did Lilienthal decide upon hearing your report? Lilienthal decided to issue the rider, but unfortunately that wouldn't be my last investigation at NHP. What do you mean by that? Well, I was once again sent there to investigate an insurance claim relating to the events of September 27th, 2014. Could you please tell the jury what happened on September 27th? Based on my investigation, I concluded that after seeing Stephen Yeager approaching the restricted area, Earhart flew the drone very close to him. Yeager was thrown from his horse. This investigation also led me to conclude that Earhart had violated the rider. Let the record reflect that I'll be approaching the witness with what has been previously marked as Exhibit 9. Let the record reflect I'm handing opposing counsel a copy.
Thank you very much.
As well as showing you the copy, I'll be handing the witness.
Thank you.
Would Your Honor like a copy?
I have copies of the exhibits. Thank you.
Yes, Your Honor. Do you recognize this document? Yes, this is the rider Lilienthal issued. And is this a fair and accurate representation of that document? It is. Your Honor, at this time, the plaintiff must enter Exhibit 9 into evidence. It has been stipulated to by both parties.
I'm sorry, any objection?
No objections, Your Honor. Thank you.
Exhibit 9 will be admitted.
How did Stacy violate this rider? Earhart violated the rider by making modifications to the drone.
Objection, Your Honor. Speculation saying that Stacey Earhart made material modifications that violated the rider. She is not designated as an expert in drone and cannot testify to the modifications or the extent to which those modifications would have affected the drone.
Your Honor,
Counsel?
may I make an offer of proof? This witness will not attempt to testify that these were material modifications based on aeronautical engineering or flight performance. Rather, this witness will testify that Stacy Earhart told her that the fins were added to change the way the drone flew, and she will highlight that this is the definition of a material modification. She will not attempt to draw a conclusion that, that they affected the flight worthiness of the drone based on aeronautical engineering, simply by Stacy Earhart's testimony.
Okay, at this time, I'm going to sustain the objection, but allow you to lay the foundation necessary for that testimony, if you can.
Yes.
Yes, Your Honor.
Thank you.
Let's talk about your first conclusion. What modifications did Stacy make to the drone? Earhart added a heavier camera to the drone, added fins to the drone, and I saw from her web history she was researching how to add dog whistles to the drone. And what does the rider say regarding material modifications? Well, Section 3 of the rider states that no material modification shall be made. That means a modification that would change the way the drone flew. Now, as an insurance investigator, how can you say that these are some of these were material modifications? Earhart admitted it to me.
Objection, Your Honor. This witness does not know what a material modification is. The court has provided a definition for the material modification, and we cannot go by Charlie Yeager's definition, as she has not been designated as an expert to make that claim in court today.
Your Honor, this witness just testified to the court's definition of a material modification in the previous question, that it is a change that significantly affects the airworthiness. This witness did not provide her own definition of a modification, rather the one that was provided by the court, Your Honor.
Under what rule of evidence are you offering this, counsel?
Your Honor, under Rule 801 D2D, she can testify to Stacy Earhart's statements as she is the party opponent. She's not going outside of her expertise to say that these are material modifications based on aeronautical engineering or flight performance, simply off of Stacy Earhart's testimony.
Okay, I'm going to sustain the objection to the extent that she calls them material modifications. That is something that the jury has to determine in the case. She will be permitted to testify to modifications, but the jury will strike any reference to material. It will be for them to determine whether the modifications that this witness testifies to are material or not. You may
Yes, Your Honor.
proceed.
Yes, Your Honor.
Were you finished with your answer? Well, Earhart told me she added fins to change the way the drone flew, which is the definition of a material modification.
Objection, Your Honor. Speculation.
Your Honor, this witness simply testified to what Ms. Earhart said. This witness helped create this rider and was involved in the previous trial and therefore would be aware of the definition of a material modification as it's been stipulated to.
I understand, counsel. I have ruled that she can testify to what Ms. Earhart told her. However, she cannot testify to whether or not it was a material modification because that is a determination that the jury must make. She can testify to modifications made, but not as to whether they're material or not. So I'm striking that portion of the witness's testimony. Do you understand, counsel?
Yes, I do.
Okay,
Yes,
you
Your
can
Honor.
proceed.
Let's move on to your second conclusion. How did Stacy violate the rider by flying the drone too close to Stephen? Well, after speaking with Finley, I learned that Earhart made 2 passes with the drone. And on the second pass, she flew it directly towards Stephen at a very high speed. According to the rider in section 6.2, the drone can't be used in such close proximity to any person. What is your final conclusion in today's case? In my expert opinion, based on 36 years of investigation, Earhart violated the rider by flying the drone too close to
Objection,
Stephen.
Your Honor. Speculation. The fact of whether or not she did or not violate the insurance policy is again up for the jury to decide, especially as this witness has not been entered as an expert to testify to the ultimate issue.
Counsel?
Your Honor, this witness is the insurance investigator for Lilienthal Insurance, and as she was called to render an opinion as to whether or not they violated the rider, that was the purpose of her investigation. Based on her testimony with in her interview with Finley Lindbergh, she is able to draw that conclusion.
Okay, I've already ruled that she is not an expert. She can give a lay opinion under 701 as to what her determination is, but she is not an expert for purposes of the jury. Do you understand?
Yes, Your Honor, this is a lay opinion as it is based on her rationally based perceptions during her investigation.
I understand, but she testified in her expert opinion, so I'm striking that portion.
Yes, Your Honor.
You may proceed.
Yes, Your Honor.
Were you finished with your answer? In my opinion, Earhart violated the rider by flying the drone too close to Stephen, and also, in my opinion, Earhart made modifications to the drone. Thank you. No further questions.
Is the defense ready to cross-examine?
Yes, Your Honor.
You may proceed.
Thank you. Ms. Yeager, you would agree with me that the letter of the law is very different than the spirit of the law. Is that right?
Sure.
Ma'am, you'd agree that the letter of the law, if you look at Exhibit 9 in front of you, which is the insurance policy, would be what the words actually say on this paper and no more, correct?
Yes.
And the spirit of the law would be how someone would interpret those words, what they would mean. Is that right?
I suppose.
Ma'am, you said that you thought Stacy Earhart violated this policy on direct examination. Is that right?
That's correct.
Ma'am, you were made aware of a complaint by your godson, Stephen Yeager, about a hunt on March 22nd when Stacy was flying this drone near where the hunt club was. Is that right?
That's right.
And ma'am, you told this jury that flying this drone near someone was a violation of this contract. Is that right?
That's correct.
And that's because you thought that flying the drone near someone was a violation of the spirit of the law. Is that right?
Yes, and the violation of the use of the drone.
Because if we look at the letter of the law, which is what the Natural Habitat Preserve received, under the 6th section, which you referenced in your direct examination, it says, the preserve shall not fly the UAS directly over any individual. Is that right?
That's right, but if that were to be the case, then Earhart could have flown the drone this close to Stephen and still not have been breaking the rider.
And
also, I believe Earhart flying the drone this near.
Yeah.
To opposing counsel's question, relevance?
Counsel?
Your Honor, this goes to show that Lilienthal Insurance own employee doesn't even know what the letter of the law of this contract means, which is what the Natural Habitat Preserve received. And more importantly, it shows that Ms. Yeager did not understand, or at least told the jury, that this was a violation when there was a clear lack of a violation according to the letter of the law.
Your Honor, may I respond?
You may.
Pursuant to the memorandum of opinion, while there are numerous FAA regulations outlined in the rider, few are at issue in today's case. Whether Stacey Earhart acted with intent, whether she added material modifications to the drone, and whether the drone was over 55 pounds. Whether or not she flew the drone directly over Stacey Earhart, or whether she did not, is not an issue in today's case. Opposing counsel's contention that Stacey did not violate the rider because she did not fly it over any individual is not relevant. This witness's testimony to Section 6.2 of the rider went to Stacey Earhart's intent, that she made 2 passes with the drone, the second one being directly towards Stephen Yeager, not that she violated the rider because of that point.
Counsel?
If I may, Your Honor, this is going to rebut the claim that the plaintiff made during direct examination that Ms. Earhart, by flying this drone near the hunt club, had violated the policy. I'm showing that that is not the case.
I overrule the objection. This is a matter that was raised on direct examination by the plaintiff, and this goes to the credibility of the witness, and I will allow it on cross-examination for that purpose.
Yes, Your Honor.
So once again, Ms. Yeager, according to the letter of the law, that complaint by your godson wasn't actually a violation of the letter of the law, was it?
Well, if you take that point literally, maybe not that point, but it definitely violated the point about what the use of the drone could be. If Stacey Earhart was using the drone to monitor and survey the hunt club, which is against the rider.
Your Honor, the witness is being non-responsive at this point. I asked her simply if that was the letter of the law, not whether or not she thought at a different point in time Stacey Earhart violated by the usage of the drone. I'm only referring to the specific complaint by her godson and how it relates to the letter of the law.
Counsel, I interpreted the witness as trying to answer your question based upon the contract, and based upon the memorandum of understanding. Therefore, I'm going to overrule your objection. She has answered your question. Move on.
Yes, Your Honor. But ma'am, you thought this was a violation of the spirit of the law, so you went to your superiors and told them to cancel this policy. Is that right?
That's correct.
But your superiors disagreed with you and didn't cancel the policy, did they?
No.
Ma'am, you also tried to say that there were modifications made to this drone and that these modifications would have violated the policy as well in direct. Is that right?
That's right.
But ma'am, don't you say that you don't even know what Lilienthal Insurance meant by material modifications in this contract?
That's irrelevant. The definition of a material modification has been set about. Whether Earhart knew that she was making a modification or not, that's irrelevant. But she did tell me she knew she was making a material modification.
Ma'am, yes or no, you say that you did not know what Lilienthal Insurance meant when they wrote material modification in this contract.
It could have been clearer.
Is that a yes, ma'am?
Objection, Your Honor. Relevance.
Counsel?
Your Honor, again, Ms. Yeager made the claim that the insurance policy was violated based on these modifications, and now she's refusing to answer a question that will completely rebut that claim.
Counsel, do you want to respond for our rule?
Yes. Opposing counsel's argument that she did not know what a material modification was because the rider was vague is not relevant. The court defined a material modification in preparation for today's case. That is the only definition that is supposed to be used, and it was made in preparation for today's case so that we could use it. Saying that the rider was vague is irrelevant, as we have the definition to use in today's proceedings.
I believe that the question is proper cross-examination regarding the credibility of the witness with regard to the witness's understanding of the contract, and therefore I'm going to overrule your objection.
So, ma'am, yes or no, you did not know what Lilienthal Insurance meant when they wrote material modifications in the letter of the law, did you?
I wasn't certain, but I was pretty sure.
Is that a yes, ma'am?
Yes.
In fact, ma'am, you go on to say that Lilienthal Insurance should have been more clear about the permissible modifications that were allowed under the contract. Is that right?
Yes, as I said.
So, ma'am, it was even your opinion that there were modifications that were permissible under this contract. Isn't that right?
That's correct. That's why the reason material is there.
Thank you. No further questions, Your Honor.
there any redirect of this witness?
No, Your Honor.
Okay, the witness may step down. Thank you. The plaintiff may call its next witness.
Yes, Your Honor. At this time, the plaintiff calls Finley Lindbergh to the stand.
Please step forward, Ms. Lindbergh. You're already under oath, so you can proceed as soon as she's ready, counsel.
Could you please introduce yourself to the court?
Hi, I'm Finley Lindbergh.
And how are you involved in today's case?
Well, in high school, I started interning at the Natural Habitat Preserve. You see, my entire life I've always been an environmentalist. I'm in college now, but every chance that I get, I'm down at the preserve working with Stacy Earhart.
And who is Stacy Earhart?
She's the manager at the preserve. She's always been really invested in NHP. I really looked up to her, but that was before everything with Stephen Yeager started.
Now, who is Stephen Yeager?
I went to high school with Stephen. His dad's the head honcho at the Wisabi Hunt Club. He always seemed to rub everybody the wrong way, though, especially Stacy after the Hunt Club repeatedly came onto land that we had blocked off.
When was the first time that the Hunt Club had interfered with the preserve?
It was September of 2013. I saw Stephen heading towards the restricted area one day, and when I told Stacy about it, she just ignored me and went on researching these drones that she was always talking about.
Now, you mentioned drones. What exactly did Stacy tell you about them?
Not much, but I remember her saying something about using a drone as high-tech border patrol, which just really bothered me.
And why did using a drone as border patrol bother you?
Something about having a powerful drone like that and using it for surveillance, it just didn't sit right with me, but the more Stacy talked about it, the more concerned I became.
And why do you say that?
Well, a couple weeks after I talked to Stacy in December of 2013, I got to the preserve one morning and I saw that the fire tower had been vandalized. And that's when I saw Stacy kneeling on the ground.
Now, you said that Stacy was kneeling on the ground. What was she doing?
She just lost it. I mean, she was banging her fists on the ground and screaming. And she said that the Hunt Club was going to pay for what they had done. Look, I wanted to say something, I really did, but I was scared, and I really had looked up to Stacy before, but I'd never seen her like that.
So what did you do?
I didn't really know what to do. I mean, the next day, she acted like nothing ever happened, and she said that the preserve had friends looking out for it, including a little metal friend.
And what did you take that to mean?
Well, it all kind of clicked a couple weeks later when I saw Stacy up in the fire tower tinkering with what she described as a state-of-the-art surveillance drone.
Your Honor, improper opinion.
Counsel?
Your Honor, this witness is not making any opinion. She is rather testifying to the exact statement that Stacy Earhart told her. This is not an opinion, but rather a statement that she herself heard.
Counsel?
Your Honor, by Finley Lindbergh saying that Stacy Earhart was up in the fire tower tinkering with the drone, Miss Lindbergh was out at the preserve doing the planting and weeding and was not up in the fire tower with Stacy, and therefore would not know exactly what Stacy was doing up in the fire tower, and therefore would be an improper opinion.
Your Honor, may I respond?
You may.
This witness just testified that based on conversations she had with Stacy Earhart, she was able to determine that Stacy Earhart told her that she was tinkering with the drone and making changes to it. Therefore, based on that testimony from Stacy Earhart, as this witness has already laid the foundation for, it is admissible.
I agree with you, counsel. Under Rule 701 of the Rules of Evidence, a lay witness is permitted to form opinions and assessments based upon things perceived, and I will permit the testimony, overrule the objection.
Were you finished with your answer?
Well, like I said before, Stacy said that it was some kind of state-of-the-art surveillance drone. She said over the next couple months, she just really started to worry me with the whole thing.
Why was Stacy worrying you?
Look, she spent all of her time tinkering with that drone, and she talked about it like nonstop, about all the changes she was making to it and about how you're not supposed to fly it near people.
Now, as far as you know, did Stacy ever fly the drone near people?
She did in March, June, and September of 2013.
Could you tell the jury a little bit about what happened in March?
Well, the Hunt Club came for their spring hunt that day, and Stacy told me that she planned on using the drone in the restricted area. Once we saw Stephen heading towards the restricted area, I reminded her how we're not supposed to be flying the drone anywhere near people, but she just ignored me.
And what happened in June?
Well, Stacy told me that she wanted to use the drone to see if Stephen was going to be in the restricted area. Sure enough, he was, and they got into a huge fight. And after that, Stacy just started to distance herself from me at the preserve.
And what happened on September 27th?
I got to the preserve that morning, and Stacy was actually already there. That's when we saw Stephen Stephen going into the restricted area. I told Stacy that we should just go down and talk to Stephen about the whole thing, but she refused.
And what did Stacy do?
Well, she just started setting up the drone for launch and telling me not to worry about Stephen anymore. And she just had this really determined look in her eye.
Miss Lindberg, this is very important. As far as you know, was there anything different about the drone on the day in question?
Look, I was with Stacy practically every day that summer. I saw a lot of the changes she made to the drone, like a camera and whatever she added to give it better control, and they were all on that day.
What happened after Stacy flew the drone?
She swerved it straight into Stephen. Look, I think about that day all the time. I mean, it's really hard not to, but I don't know. I just wish that there was something that I could have done to change the outcome, but she just wouldn't listen to me.
Thank you, Miss Lindberg. Your Honor, I have no further questions.
Thank you, counsel. Is the defense prepared to cross-examine?
Yes, Your Honor.
You may proceed.
Finley, this drone Stacy Earhart purchased was to be used for conservational purposes, isn't that right?
That was one of the purposes that she told me.
In fact, she told you that her primary purpose was to help with the restoration project, correct?
Yes, and then she said something about
Objection,
using it.
Your Honor. Hearsay.
Your Honor, pursuant to Rule of Evidence 803, subsection 3, I'm using this for Stacy Earhart's then existing motive, intent, or plan, specifically her plan for how she was going to use the drone.
Your Honor, may I respond?
You may.
Pursuant to Rule 803.3, the statement must be made contemporaneously with the intent that she had. This statement was made months before she actually acquired the drone, and therefore this statement does not fall under hearsay exception Rule 803.3.
Counsel?
Your Honor, Stacy Earhart was talking about why she wanted to purchase this drone and her intent for how she was going to use it when she purchased it, and therefore would be a hearsay exception and fall under the exception 803.3.
Well, counsel, plaintiff's counsel has correctly stated that if you're under 803.3, then existing mental, emotional, or physical condition, the statement must be made contemporaneously with the event in question. Do you understand?
Yes, Your Honor.
In this case, you haven't laid that foundation, therefore I'm going to sustain the objection.
Yes, Your Honor.
You may proceed.
Finley, Stacy Earhart used the drone for conservational purposes on March 22nd of 2014, correct?
Yes, that was the plan, but when I saw her going into the restricted area with the drone, and then that's when we saw Stephen, she said something about how there was an extra benefit to using the drone during the clock times.
That's a yes, she used it to take pictures.
Objection, Your Honor. I ask that the witness be allowed to completely finish her response before opposing counsel cuts her off.
I will allow her to finish her response, counsel, but she should give an answer first before explaining.
Yes, sir.
Okay?
So, ma'am, that's a yes. Stacy Earhart used it for conservational purposes on March 22nd?
Yes.
In fact, on this day, she was planning to take pictures of the pitch pine saplings. Isn't that right?
Yes, which I thought was kind of weird because we'd just gotten some great pictures the day before.
Well, Finley, you were actually up in the fire tower with Stacy this day because you were directing her toward the pitch pine saplings, weren't you?
Yes, sometimes she helped me with my own projects at the preserve.
And as you were directing her to this area of restoration, you say that a hound just happened to appear in the monitor, correct?
Yes, that's exactly what happened.
And Stacy Earhart stopped flying the drone and went down to see what was going on in the restricted area, right?
Yes, but that same day she said something about how there was an extra benefit to using the drone on the fox hunts.
Well, ma'am, you were expecting Stacy to be angry at Stephen when you found him in the restricted area, but we're surprised she wasn't. Isn't that right?
Yeah, she seemed kind of passive-aggressive.
Your Honor, I ask that be stricken as an improper opinion, as it is a psychological diagnosis to say that Stacy Earhart was passive-aggressive.
Your Honor, may I respond?
You may.
Opposing counsel asked this witness what she thought Stacy Earhart would or would not act. That opened the door for this witness to testify to such. Just because this answer was not what opposing counsel wanted does not make it inadmissible.
Counsel?
Your Honor, I asked if Stacy Earhart appeared angry, not for the witness to give a psychological diagnosis, just her observations.
She answered the question yes, I believe, and then tried to explain. So I will permit that answer to stand.
Now, Finley, just a few months later, on June 15th of 2014, again, Stephen Yeager rode into the restricted area, didn't he?
Yeah, and it was kind of weird because that same day, Stacy wanted to use the drone to see if he would be in the restricted area.
Well, this time, Stephen actually led a pack of hounds right past the construction tape, correct?
Yes.
And again, Stacy Earhart stopped flying the drone and went down to the restricted area to see what was going on. Isn't that right?
Yeah, she went down to confront Stephen about it, and that's when she started threatening him.
Well, Stephen Yeager yelled that no matter what you or Stacy said, he would continue riding into the restricted area however he pleased. Isn't that right?
Objection, Your Honor. Hearsay.
Your Honor, I am not using this for the truth of the matter, but rather to show how it could have affected Stacy Earhart's decision to fly the drone on September 27th of 2014.
Your Honor, may I respond?
You may.
Opposing counsel is attempting to use this statement for the truth of the matter asserted when Stephen Yeager said that he would be allowed to go on the restricted area and how Stacy Earhart would take that to mean the truth. Therefore, pursuant to Rule 801, this is going to show the truth of the matter asserted and is inadmissible.
Counsel, I'm going to overrule your objection. There has been a legitimate basis other than the truth of the matter stated for the question, and therefore I will permit it for that purpose.
Yes.
So thus, yes, Finley, no matter what you or Stacy said, Stephen Yeager would continue riding into this restricted area, correct?
I think he said something like that.
Now, Finley, September 27th was very different than June 15th and March 22nd in that you couldn't confront Stephen on foot this day, could you?
Well, I don't think I was trying to confront him on foot. It's just, it was weird because every single time that the hunt club came to the preserve, Stacy always managed to have a confrontation with them.
Well, you couldn't confront Stephen on foot this day because Stephen Yeager was actually galloping into the restricted area, wasn't he?
Yes, and right as he galloped into the restricted area, Stacy started preparing the drone for launch.
And not only could you not confront Stephen because he was galloping into the restricted area, but you and Stacy had also been present when Stephen had said that he would continue riding wherever he pleased, right?
Well, I'm not sure I understand your question.
You couldn't confront Stephen because he was galloping into this area and because you and Stacy had been present when Stephen had said he would ride wherever he pleased, right?
I mean, I wasn't planning on confronting Stephen. I mean, I was just there to help Stacy that day with the conservation purposes, but then she started using the drone for surveillance. I mean, I wasn't a part of that.
Well, Finley, Stacy Earhart didn't fly this drone until Stephen was in the restricted area. Isn't that right?
Yes, I mean, right as we saw Stephen go into the restricted area, Stacy started to prepare the drone for launch.
And it was your belief that Stacy Earhart simply wanted to get a picture of Stephen Yeager on his galloping horse in the restricted area on this day, correct?
I was not really relieved about that. I mean, I don't like using a drone for surveillance.
Is that a yes?
Yes.
And you say that Stacy was maneuvering this drone wildly trying to get this picture, don't you?
I mean, I don't really know what she's doing. I wasn't really familiar with drones that much, but yes.
And you say that Stacy Earhart could not get a picture. Isn't that right?
Objection, Your Honor. Speculation.
Your Honor, this is rationally based on the witness's perception. Finley Lindbergh was up in the fire tower with Stacy Earhart this day. She observed everything that Stacy said and did.
Your Honor, may I respond?
You may.
Firstly, none of that foundation has been laid for the courts and for the record, so I would ask that opposing counsel lay that foundation if she does intend to continue with this line of questioning. Secondly, Your Honor, this statement as to whether or not she was able to fly the drone and get a clear picture is not based on this witness's rationally based perception, as she was not the one that was directing the drone, she was not the one that was flying the drone, and she could not tell whether or not Stacy Earhart was able to get one.
I understand your objection, counsel, but there's been testimony that lays the foundation for this question based upon her presence that day, her location, et cetera. So I'm going to overrule your objection, and I think the question is proper. You may proceed, counsel.
So that's a yes, ma'am. You did not observe Stacey Earhart get a picture on this day, did you?
I mean, I don't really know what she was doing with the drone, but I guess she didn't get any pictures.
And Finley, you say that Stacey Earhart or Stephen Yeager actually went out of view from the camera for a while, didn't he?
Yes.
And then Stephen finally came back into view, didn't he?
Yes.
And you say that when he did come back into view, Stacey Earhart's hands went all over the control panel, don't you?
I saw Stacy push the controls all the way to the right, and then that's when it went straight towards Stephen.
So that's a yes, ma'am? Her hands went all over the control board?
Yes.
And you say that she had a look of shock on her face, don't you?
I mean, I can't really tell what she was feeling, but that's what it kind of looked like.
You said that her eyes went wide, right?
Yes.
And it was only a few seconds after Stephen Yeager appeared in the monitor that the drone crashed. Isn't that right?
Yes.
And Finley, the first thing that Stacey Earhart said when the drone crashed was that she lost control. Isn't that right?
That's what she said, but I mean, after everything that had happened, all of the confrontations, I wasn't really sure what to believe anymore.
So that's a yes, ma'am. She said she lost control?
Yes.
Thank you. No further questions, Your Honor.
Any redirect examination?
Briefly, Your Honor.
May proceed.
Ms. Lindberg, on September 27th, when exactly did Stacey begin to fly the drone?
Well, it wasn't until we saw Stephen heading towards the restricted area that she started to prepare the drone for launch.
Thank you. Your Honor, no further questions.
Is there any recross based upon that question?
None, Your Honor.
Okay, witness can step down. Does the plaintiff have any other witnesses?
Yes, Your Honor. The plaintiff calls Ms. Val Coleman to the stand.
Please step forward, Ms. Coleman. You're already under oath. You may proceed, counsel.
Yes, Your Honor. Can you please introduce yourself to the court?
Good afternoon. My name is Val Coleman.
What do you do for a living, Ms. Coleman?
I'm an aeronautics consultant and a crash investigator.
What is your educational background?
I earned a degree in mechanical engineering from Oklahoma State University and a master's in material engineering from the California Institute of Technology.
Can you please describe your professional experience?
I was in the Mission Specialist program at NASA for 15 years, where I modeled space collisions and trained to become an astronaut. After this, I transferred to the National Transportation Safety Board, or the NTSB, where I specialized in aircraft crash investigation.
What did you do after the NTSB?
Well, I co-founded my current firm, Shepard, Weir, and Coleman, where, among other things, I perform root cause analysis for drone crashes and prepare applications for drone airworthiness certification.
Ms. Coleman, did you render an opinion for today's case?
Absolutely.
What materials did you rely upon in rendering your opinion?
I reviewed all of the exhibits and all of the affidavits, focusing specifically on Stacey Earhart's statement as well as the insurance rider.
Are these the types of materials typically relied upon by experts in your field?
Certainly.
And did you render all the opinions you're going to share with us today to a reasonable degree of scientific certainty?
Absolutely.
Your Honor, the plaintiff offers Ms. Val Coleman as an expert witness in the fields of materials engineering, aviation crash investigation, and aeronautics.
Defense counsel?
Your Honor, I find the field of aeronautics to be extremely broad, and since that is not a field that was not stipulated to by both sides, I don't think enough foundation has been laid to enter this witness as an expert in the field of aeronautics. In the specific area of aircraft crash investigation, she is more than qualified, but in general aeronautics, she is not qualified.
Your Honor, may I be heard?
You may, and counsel, the areas that are indicated in the materials, in addition to mechanical engineering, crash investigation, are unmanned aerial systems and mechanical engineering. Which of these fields are you offering the witness as an expert in?
Your Honor, I apologize. Are you referring to the stipulated expertise?
Well, I'm just saying that these are the areas usually, based on the materials, that the witness can be qualified in. What do you mean by aeronautics?
Your Honor, the plaintiff offers Ms. Coleman as an expert in the general field of aeronautics or aeronautical engineering. Your Honor, pursuant to Rule 702, a witness may be qualified as an expert by knowledge, skill, experience, training, or education. Ms. Coleman testified that she is an aeronautics consultant.
Okay, counsel.
Your Honor, I understand that Ms. Coleman may be an aeronautics consultant, but there has been nothing offered to the court as to how much experience she has in this field, whether she has proper experience and proper knowledge in this field. Merely owning a firm that consults with aeronautical properties does not qualify her to be an expert in that field, and it has not been demonstrated that she has expertise in anything other than aircraft crash investigation and materials engineering.
May I be heard, Your Honor?
Okay, counsel.
The witness testified that she worked at the National Aeronautics and Space Administration for 15 years. Then she then went on to work at the National Transportation Safety Board, where she specialized in aircraft crash investigation, which deals with aeronautical principles, for 12 years. And then finally, she worked at her own firm, where she specializes in aircraft crash investigations as well. Your Honor, Ms. Coleman has been using the field of aeronautics throughout her over 30 years of experience in this field.
Okay, both Pennsylvania and federal law have a fairly liberal standard of expert qualifications necessary to testify. I will so recognize the witness as an expert in these three areas, but permit the defense to cross-examining her regarding her qualifications during the cross-examination.
Yes, Your Honor.
You may proceed.
Ms. Coleman, we've heard a lot about drones today, but what exactly is a drone?
A drone is essentially aircraft without a pilot. Now, what you have to understand is that drones are a very new and potentially dangerous technology. And so with the power of using a drone comes the responsibility of using it safely and following the rules.
Did Stacey Earhart meet that responsibility?
Unfortunately, no. Ms. Earhart violated 2 of the structural restrictions that were contained within the rider by
Objection, Your Honor. At this time, the witness is testifying to the insurance rider in today's case. She's not a representative of the company or someone that was given this insurance policy. For her to offer expert opinions on aeronautical principles or on material modifications, I have no objection to that. But to say the rider was actually violated, that is not something within her area of expertise.
Counsel?
Your Honor, may I respond, Your Honor?
You may.
Pursuant to Rule 703, an expert witness may testify about any facts or data that she either observed or was personally made aware of. Ms. Coleman testified earlier, before she was tendered as an expert witness, that she reviewed all the exhibits and all the affidavits in preparing for this case, and that she specifically focused on the rider, which is Exhibit 9. Furthermore, Your Honor, Exhibit 9 has already been entered into evidence, as Ms. Coleman has reviewed Exhibit 9, and considering the fact that it is in the record, Ms. Coleman can testify about that exhibit.
Counsel, to be consistent with my prior rulings, that is for a jury to determine. You can ask this witness questions regarding what was done to the drone and her opinions with regard to that, but she will not be permitted to testify as to whether or not those matters violated the rider, because that is a matter for the jury.
Yes, Your Honor.
You may proceed.
Ms. Coleman, what were the 2 main structural conditions contained within the rider?
No material modifications, and the drone cannot weigh over 55 pounds.
Well, let's take those one by one. What modifications did Stacey Earhart make to the drone?
Ms. Earhart made 5 modifications. She added a new, heavier camera, brackets, advanced rotors, fins, and a whistle device.
In your expert opinion, are these modifications material?
Absolutely.
Well, what makes a modification material?
A material modification is any modification that could have affected airworthiness or the way that a drone flies. You see, each individual modification adds extra weight to the drone and changes the shape of the drone ever so slightly, and as a result, drastically affects airworthiness.
Can you please elaborate?
Well, I'll put it on a simpler scale. Think of a paper aeroplane and how adding an extra fold or even something as light as a paperclip.
Objection, Your Honor. Relevance. I find that this is misleading the jury.
Your Honor, may I be heard?
1 minute, counsel.
Yes, Your Honor.
Why is it misleading to the jury, counsel?
I do not believe that the example of a paper airplane and the aeronautical principles of that aircraft would be applicable necessarily to the aircraft in this case. I ask if Ms. Coleman wants to make an expert opinion about the aeronautical properties of a rotodrone, that she referenced the rotodrone and not something else.
Counsel?
Your Honor, opposing counsel's objection goes to weight, not admissibility. The reason Ms. Coleman is here is because she is an expert witness and she's here to assist the trier of the fact in understanding complex principles of aeronautics, of flight performance, and of crash investigation. Your Honor, Ms. Coleman isn't saying explicitly or literally that the principles of a drone exactly match the principles of a paper airplane. She's saying that she's explaining the principles of a drone on a simpler scale and simply providing an analogy for the jury to understand these complex principles. Your Honor, if opposing counsel would like to explore the issue of why a paper airplane is different from a drone, he can do so on cross-examination.
I understand, counsel. That last part is for me to determine.
Yes,
but
sir.
I agree with the first part of your objection, and that is that his objection goes to the weight and not the admissibility of the evidence, so I'll permit the answer to stand thus far.
Yes, Your Honor. Can you please further elaborate, Ms. Coleman?
Well, as I was saying, when you're a child and you play with a paper airplane and you fold it in different ways, you affect aerodynamics. Even something as light as a paperclip, like I said before, will make the difference between your plane flying and your plane nosediving.
Why do you believe that Stacey Earhart's modifications in particular were material?
Well, each modification that Miss Earhart made added extra weight to the drone, but the fins and the whistle device were particularly concerning because these directly affected airflow, or in other words, airworthiness.
Let's move on to the second restriction. How did you come to the conclusion that the drone weighed over 55 pounds?
Well, I found a little over 45 pounds of drone debris at the site and then applied the 80% rule.
What is the 80% rule?
The 80% rule is an industry standard accident reconstruction model. It was developed by the NTSB with almost a century of experience. It essentially says that it is quite rare to find more than 80% of the debris of any aircraft, even with the best possible search.
In your expert opinion, how much did the drone weigh on the day in question?
According to the 80% rule, 56 to 57 pounds.
What is your final expert conclusion for today's case, Ms. Coleman?
It's my opinion, to a reasonable degree of scientific certainty, that material modifications were made to the drone and the drone weighed over 55 pounds.
Thank you, Ms. Coleman. Your Honor, I have nothing further.
Is the defense ready to cross-examine this witness?
Yes, Your Honor.
You may proceed.
Ms. Coleman, on direct examination, you mentioned an aeronautical principle of a paper airplane. Is that right?
Yes.
And a paper airplane would be a small fixed-wing aircraft that flies by gliding, correct?
Of course, and if you affect different parts of the airplane, it glides in a different way, much like a drone would fly.
Of course, but this drone did not fly in this manner. It was actually a rotodrone that had 4 rotating propellers. It did not glide, did it?
Yes, but these rotating propellers made airflow even more important.
So is that a yes, ma'am? This drone did not glide as it had propellers?
No, it didn't.
Now, ma'am, did you state on direct examination that you made all of your conclusions to a reasonable degree of scientific certainty?
Absolutely.
But isn't it true that you're actually not scientifically certain about the weight of the drone?
Well, nothing is ever 100%, but I have a reasonable degree of scientific certainty. The drone weighed over 55 pounds.
But ma'am, it is an estimate. And because it is an estimate, you say that it's merely possible that the drone was over 55 pounds, right?
I have it to a reasonable degree of scientific certainty. The drone weighed over 55 pounds.
Ma'am, is that a yes? In your statement, you say that it was merely possible that the drone was over 55 pounds.
Highly possible, yes.
Now, ma'am, when you investigated this crash scene, all you could find was debris, correct?
Of course.
You actually could not clearly identify any modifications in that debris, could you?
No, the weather had been horrible. It was incredibly difficult to even find parts in that area.
So you couldn't even tell if any of those modifications were present on the drone or not, could you?
Not at first, no.
So, ma'am, you made a claim on direct testimony that there were extra rotors for the turbines added, right?
Yes.
But you would be aware, it was your opinion that these were bought by the Natural Habitat Preserve, right, ma'am?
I can't think of another way they could have got there, no.
Well, ma'am, if they had been bought by the Natural Habitat Preserve, naturally there would be receipts, correct?
I don't know
Objection,
whether...
Your Honor. Outside of the scope of the witness's expertise.
Your Honor, I am questioning the witness's investigation and the lengths she took to ensure whether these modifications were present on the drone before she made her testimony to the jury. This is questioning the credibility of her findings and her investigation.
Counsel?
Your Honor, opposing counsel is asking the witness to testify about receipts that the Natural Habitat Preserve bought when they purchased this rotor turbine. Ms. Coleman isn't here to testify about how the preserve obtained the modifications, simply whether or not modifications were present on the day in question.
I believe, counsel, that that's exactly what the question goes to, and it goes to the issue of the investigation of the expert and therefore her credibility. So I'm going to overrule your objection.
Yes, Your Honor.
You may continue.
So, ma'am, when you continued your investigation after finding that you thought these rotors had been bought, you never found any receipts for those rotors, did you?
No, I saw rotors. I assumed they'd been bought. How else would they have got them?
Ma'am, you never saw those rotors in that crash site. Can we make that clear?
I knew there were rotors on the drone on the day in question.
But you could not identify anything like that in the crash site, right?
Yes, I could.
Your Honor, at this time, the witness is making an unfair extrapolation of case materials. Witnesses are bound by the statements offered to the court. I am questioning the witness on an omission in her statement, which is allowed by Rule of Evidence 611 when it goes towards cross-examination. I ask if opposing counsel can find anything in the witness's statement that says she actually found these in the crash site, but I do not believe there's anything in the witness's statement that says that.
Your Honor, may I be heard?
Give me 1 second.
Yes, sir.
Can you point me in the witness's statement where there is something from which an extrapolation or an inference can be raised?
Yes, Your Honor. 1 moment, please.
Okay.
Your Honor, I can't find the specific line, but I do know that Ms. Coleman does state in the affidavit that she found after investigating the debris, she found everything that we knew was on the drone, and she states in her affidavit that she knew there were rotor turbines on the drone. Your Honor, I specifically can't find the line, but I'm sure if opposing counsel brought the affidavit to Ms. Coleman, she'd be able to point it out for him.
Well, counsel, the objection is that it goes beyond the scope of the statement and is not a fair extrapolation. According to the rules, the court has discretion to determine, based upon some statement, as to whether or not there is something from which the extrapolation may be drawn. And he's simply asking the witness whether any rotors were found at the crash scene and that whether she found any. Can you point me to something in the affidavit from which that can be inferred or extrapolated?
Your Honor, pursuant to the rules of competition, an objection to unfair extrapolation is better gone through by impeachment by omission. Ms. Coleman, if she were given the affidavit, would be able to point out the line from which she is extrapolating this testimony.
Well, counsel, I think it's, once the objection is made, it's up to opposing counsel. The appointment is something. In the absence of that, I am going to sustain the objection and strike the answer from the record.
Yes, Your Honor.
You may proceed.
So, ma'am, you never mentioned in your statement that you found these rotors and turbines in the wreckage, did you?
Through my investigation, I found that there were rotor turbines, and I state in my affidavit that I found everything I knew to be on the drone.
So that's a yes, ma'am. You never say in your statement that you found these rotors in the debris of the crash site.
Not explicitly, no, but I do infer it.
Now, when a drone crashes, ma'am, there's any number of factors that can cause, cause the crash, right?
Absolutely.
And it's possible that novice pilots can become nervous and jerk the controls, resulting in a crash, correct?
Yes, it is possible.
And it's your opinion that Stacey Earhart is actually an inexpert pilot, right?
Yes, and when her material modifications got caught in the wind, she had no way to control her drone.
So that's a yes, ma'am. You do believe that Stacey Earhart is an inexpert pilot?
Absolutely.
Thank you. No further questions, Your Honor.
Is there any redirect examination?
Yes, Your Honor. May I proceed?
You may.
Ms. Coleman, I'm approaching you with your affidavit. Can you please point out the line number to which opposing counsel was referencing on cross-examination?
To which opposing counsel was referencing?
Ms. Coleman, the line number where you say that you found everything that you knew was on the drone.
Oh, yes. Line 113 to 14, I'm sorry. The area, honestly, we're lucky we got what we did, according to the 80% rule, which included at least pieces of everything we know was on the craft.
And, Ms. Coleman, did you know that rotor turbines were on the craft due to your investigation?
Yes, I did.
Your Honor, at this time, the plaintiff motions to re-enter the stricken testimony into the record.
Counsel, the witness has already testified to it without objection, so it is in the record. You don't need to do that.
Yes, Your Honor. I have nothing further.
Okay. Any recross?
No recross, Your Honor.
Okay. You can step down. Does the plaintiff have any other witnesses?
No, Your Honor. At this time, the plaintiff rests his case in chief.
Thank you. Is the defense ready to proceed?
Yes, Your Honor, but before we do, we'd like to call for an official time check.
Okay. Where is the official timekeeper? Oh, okay.
The defense has about 16 minutes and 30 seconds left.
And the plaintiff has 14 minutes and 36 seconds left.
Thank you. You may proceed now to call your first witness.
Yes, Your Honor. The defense calls Mr. Quincy Wright to the stand.
Mr. Wright, you're already under oath. Take the stand and just make sure you speak into the microphone, or toward the microphone anyway.
May I proceed, Your Honor?
You may.
Could you please state your name and your age for the court?
I am Quincy Wright, and I am 80 years old.
What is your occupation, Mr. Wright?
Oh, well, you see, I'm an accountant by trade, but I'm retired now. So instead, I spend most of my time working at the Natural Habitat Preserve.
What is your position at the preserve?
Oh, well, I'm actually the president of the board of directors.
Mr. Wright, are you familiar with Miss Stacey Earhart?
Oh, well, of course I am. I hired her myself.
Why did you hire her?
Well, you see, we were trying to draw more attention back to the preserve, and to be honest with you, our old manager was really only good for shoveling snow. So we got this more youthful and energetic person named Stacey.
And what did Stacey do as manager?
Well, she handled the project that she created, and as well as our day-to-day affairs at the preserve.
Mr. Wright, what was this project?
Really, it was a genius idea. Stacy separated the land into 7 different sections, would work on each one for about 2 years, and would restore it to its natural way.
How was she able to monitor her progress?
Oh, well, she couldn't. You see, this land was 500 acres a section. It was far too much for her to walk every single day. And so she came to me one day and asked for a flying camera to help her with her work.
Mr. Wright, what was this flying camera?
It was something that she called a drone.
Did you have any concerns about using a drone at the preserve?
I did have one, yes. You see, I realized this could potentially be a hazard, and so I wanted insurance in case anything were to happen.
Did you acquire insurance?
Yes, I did, through Lily Anthal.
Your Honor, may I approach the witness with what has been previously marked as Exhibit 9 and already admitted into evidence?
May?
Mr. Wright, do you have the copy that is already admitted into evidence in front of you?
I don't believe so, no.
This is the copy I will be showing to the witness.
Thank you.
You're welcome. Mr. Wright, do you recognize this document?
Well, yes, I do. This is the policy that we are granted from Lily Anthal for our drone.
And how are you familiar with this policy?
Well, as the president of the board of directors, it was my job to read through, and I even signed off on this policy.
What exactly did this policy cover?
Well, it speaks of here what we could and couldn't do with the drone, where it could be flown, and what changes were allowed.
What did it say about changes?
Well, it says that the drone is not allowed to go over 55 pounds.
Were you ever concerned that the drone was over 55 pounds?
At one point, yes. You see, Stacy had come to me and asked for a better camera to help her with her work. So we took off the old camera, added on the new one, and I weighed it. I saw that it was under 55 pounds, though, so I said, go on ahead.
Mr. Wright, how did you know that Stacy Earhart had purchased this camera?
Well, I received a receipt for it.
Did you receive a receipt for anything else?
No, I never did.
And Mr. Wright, were there ever any concerns about the usage of this drone?
Unfortunately, yes, there was one concern.
What was that?
Well, you see, Lily Anthal gave us a call and said that the Hunt Club was worried about how we were using our drone.
How did you respond to these concerns?
Well, no one really seemed to get that worked up about it. We just talked about it, and they didn't seem to think we'd breached the policy, and so we were all good.
And after contacting Lily Anthal, was the rider changed in any way?
No, it was not.
Did you have any further contact with the Lily Anthal?
Oh, yes, I did. You see, I called them back, and I wanted to speak about how and where we could fly this drone.
What did Lily Anthal say?
Well, I contacted Hugo Junkers, our agent at Lily Anthal, and the person who wrote up this policy here. We came to the conclusion that I was allowed to fly it in the restricted section.
And after being told that you could fly the drone in the restricted section, did you receive any written clarification regarding your policy?
No, never.
Now, Mr. Wright, was the Hunt Club permitted in this restricted area where you could fly the drone?
Oh, well, absolutely not.
Why was that?
Well, it's been part of our contract with them since 1959.
Your Honor, may I approach the witness with what has been previously marked as Exhibit 2?
You may.
Opposing counsel, would you like a copy? This is the copy I will be showing to the witness.
Thank you.
You're welcome. Mr. Wright, do you recognize this?
Oh, well, of course I do. In fact, I was alive when we made this back in 1959.
What exactly is it?
What's our memorandum of understanding, our agreements between the Hunt Club and the Natural Habitat Preserve.
Your Honor, I ask that Exhibit 2 be admitted into evidence.
Any objection?
No objection, Your Honor.
Exhibit 2 is admitted.
Mr. Wright, according to this memorandum, why couldn't the Hunt Club be in the restricted area?
Well, you see, at the preserve, we're all about the conservation of the land. We couldn't just have the Hunt Club trampling through on their horses, destroying all of our hard work. And so we came up with an agreement. They were allowed to hunt on our land so long as they stayed off of our restricted sections.
And what would happen if they were found in the restricted section?
Well, I suppose we would have to kick them off the land.
And Mr. Wright, who signed this document in regards to the Hunt Club?
Let's see here. That was Thaddeus Yeager IV.
Thank you, Mr. Wright. No further questions, Your Honor.
The plaintiff may cross-examine.
Yes, Your Honor. May I proceed?
You may.
Now, you're the president of the board of directors at the Natural Habitat Preserve, right?
Oh, yes, that's right.
You've been the president for over 55 years.
Indeed. I'm a bit of an old man now, I realize.
And as you said on direct, the Hunt Club has been hunting on the preserve's land since 1959, right?
Yes.
And we can agree that from 1959 to 2013, there have been no altercations between the preserve and the Hunt Club.
Yes, we got along just fine and just dandy. It was great.
And then you hired Stacy Earhart in 2012, isn't that right?
Well, yes, that's right.
And then a year later, in 2013, Stacy came up with a complete reconstruction plan, right?
Well, yes, it was a genius idea, like I said.
And Stacy blocked off the first restriction March of 2013, right?
If memory serves, yes.
And this was the first time that land had ever been restricted at the preserve.
Well, it was the first time for this project. Yes, it was.
It was the first time that the Hunt Club had ever been restricted in terms of where they could hunt, right?
For this project, yes.
And in your own opinion, Stacy did not do a good job providing the Hunt Club notice of this new change, right?
Well, she didn't do the best job ever, but it was pretty clear.
But to be clear, in your own opinion, Stacy did not do a good job, correct?
Well, not as good as she could have. She was an excellent worker, and so it was a little bit odd to see a little less than her average work.
And then an altercation soon erupted between Stephen Yeager and Stacy Earhart, right?
Yes, the Yeager family wasn't too pleased with this whole restricting of the land, but it was part of our contract. I figured they should understand.
Let the record reflect I'm approaching opposing counsel and in turn the witness with what has been previously marked as Exhibit 4. Would you like a copy?
Yes, please. Thank you.
And this is the copy I'll be showing the witness. Yes. Your Honor has a copy.
I have a copy, thank you.
Thank you.
Now, Stacy sent this letter after the altercation in March of 2013, right?
Yes, that's right.
She sent it out to all members of the preserve, right?
Yes, I believe so.
And it's a fair and accurate representation of that document?
Yes, it appears to be.
Your Honor, at this time, the plaintiff moves to enter Exhibit 4 into evidence.
Any objection?
No objection, Your Honor.
Exhibit 4 is admitted.
Now, in the second line on the first page, Stacy wrote, "I am shaking with anger as I write this email," right?
Yes, that's what it says here.
And on the back, the second line of the first paragraph, the Hunt Club had selfish and inconsiderate behavior, right?
Yes, that's right.
And then she wrote, "I, for one, believe that a better tactic is an eye for an eye."
Oh, she did write that, yes.
And then the second line, she said, "I, for one, will not stand by and let this happen again."
She did say that, but as you see, she later on goes on and says that how she's using her voice to solve these problems, not any actions.
But to be clear for the jury, she wrote that "I will not stand by and let this happen again."
Oh, yes, that's right. She did write that.
And then she wrote, "If our voices aren't heard, our actions will be felt."
Well, yes, that's right, but I feel like you're missing the point here. This was to say she was going to use her voice as a pacifist and to draw attention to her work.
Mr. Wright, I'm not asking you to interpret what she meant. I'm simply asking you what's written in this document.
Sorry,
She
ma'am.
said, "Our actions will be felt." Yes or no?
Oh, yes, she does say that here.
And she sent this only after one altercation, isn't that right?
I believe so.
But we can agree that there was another altercation during the spring of 2014, hon.
Yes, like I said, the Yeager family really did not like our restricted sections. We thought they'd honor them, but they just wouldn't.
Exactly, and Stephen Yeager even sent a letter to Lilienthal Insurance saying that you violated the contract, right?
Why, yes, the kid certainly had moxie.
And then you approached Stacy and said if you found out that she was using the drone as a weapon, she would be fired in an instant.
Well, of course. We loved the Hunt Club. We never wanted to harm them or do anything to them.
But to be clear for the jury, Stacy did fly the drone on September 27, 2014.
Yes, she did fly the drone.
Now, on direct examination, you mentioned the Memorandum of Understanding. Now, you've had this Memorandum of Understanding since 1959, right?
Yes, that's right.
It was what you and Thaddeus Yeager signed to establish a relationship between the preserve and the Hunt Club, right?
That's correct.
Now, you have the document in front of you. That's your signature on the bottom, right?
Yep, that's the one.
And that's Thaddeus Yeager's next to it, right?
Indeed.
Now, you claim that Stephen Yeager trespassed on the Hunt Club's land, didn't you? On the preserve's land, right?
Well, yes, that's right, he did.
Well, I'd like to point you to point 5 under Section E. It says, "At no point shall any member of the Hunt Club be deemed to be trespassing on the land of the preserve," right?
Well, it does say that here, but you're misinterpreting our contract here.
Mr. Wright, is that what is written in the document?
Well, it does say that here, but let me explain. If they were to ever be found on our restricted sections too many times, then we would have to kick them off the land.
And then it goes on to say, regardless of time of day, season, or purpose. That is what's written.
Oh, I'm sorry. Could you point to where that is?
Right, the remainder of point 5.
Oh.
That's what it says, regardless of time of day, season, or purpose.
Oh, yes, that's right.
Thank you, Your Honor. No further questions.
Is there any redirect examination of this witness?
Briefly, Your Honor.
Go ahead.
Mr. Wright, when this email was written, did Stacey Earhart purchase the drone?
Had she purchased the drone by this point?
Yes.
I believe so.
And Mr. Wright, could you read the second point under E of the Memorandum of Understanding?
Certainly.
Part 2 under E of the Memorandum of Understanding. Could you read it out loud, please?
It says here that such restrictions may include sectioning off specific parts of the land for regular and systematic maintenance or conservation activities.
And was the Hunt Club to abide by that rule?
Well, absolutely. It's part of our contract.
Thank you. No further questions, Your Honor.
Is there any recross examination?
No recross, Your Honor.
The witness may step down. Does the defense have another witness?
Yes, Your Honor. At this time, the defense would like to call Miss Stacey Earhart to the stand.
Ms. Earhart, come forward. You're under oath.
May I proceed, Your Honor?
You may.
Thank you. Could you please state your name for the court?
Stacey Earhart,
And how old are you, Miss Earhart?
36.
Are you currently employed?
Yes, I'm very grateful to be the land manager at the Natural Habitat Preserve in Whistler, Pennsylvania.
Miss Earhart, as the land manager, what exactly do you do for the preserve?
Honestly, I do pretty much everything. Of course, I don't do legal work or documents, but if it deals with maintaining the land or handling the public, then that's all part of my job.
And were you familiar with the restoration project going on at the preserve?
Oh, yes, of course. I came up with it myself.
And could you please explain for us how large this project was?
This project was enormous. It encompassed the entirety of our preserve, 3,500 acres, and it was going to take approximately 14 years to complete. The section that we are currently working on is 500 acres, so as you can see, this is a very large project, and it's very important to me.
And how are you keeping an eye on such large swaths of land?
Well, originally, that was the problem. My intern, Finley Lindbergh, and myself were having a lot of trouble walking this 500 acres every day to monitor our plant growth. And then I remember Finley Lindbergh mentioning to me that there was something called a recreational drone, and that we could use it with a camera to monitor our plant growth.
Objection, Your Honor. Hearsay.
Counsel?
Your Honor, this testimony is not being offered for the truth of the matter, but rather to show the subsequent actions of Miss Earhart in her deciding to purchase the drone after being told this.
Your Honor, may I respond?
You may.
The fact that Finley Lindbergh stated that, told Stacey Earhart about a recreational drone is being offered to prove the truth of the matter asserted, that Finley Lindbergh was the one who told Stacey Earhart about a recreational drone, and that is how she got the idea of it. Therefore, pursuant to Rule 801, it is inadmissible.
Counsel?
Your Honor, we're not offering the fact that the drone was recreational or not for the jury here today, simply trying to explain why Ms. Earhart decided to purchase this drone.
I'm going to overrule the objection. I think it's a legitimate basis for the offer of an out-of-court statement for a purpose other than the truth of the matter asserted, and we'll consider it non-hearsay.
Yes, sir.
You may proceed.
And Ms. Earhart, did you ever acquire the drone?
Yes, after I did some research and found out what it was, I petitioned the board to buy one.
Besides petition the board, Ms. Earhart, did you have to do anything else to get this drone?
Yes, Quincy Wright insisted that we get insurance, and in order to do that, an interviewer had to come and talk to me about the policy.
And do you remember how this interview went?
Oh yes, I do. I remember it was a woman by the name of Charlie Yeager who came to interview me.
And can you please describe for us how exactly that interview went?
Let me tell you, from the very beginning, this was not an interview, it was an interrogation. Charlie Yeager was grilling me with question after question.
Objection, Your Honor. Speculation.
Counsel?
Your Honor, this is a rationally based perception on the part of Ms. Earhart that Charlie Yeager came in and was grilling her with questions.
Your Honor, may I respond?
You may.
My objection goes towards the fact that this witness just testified that this was not a regular interrogation. As Charlie Yeager is an insurance investigator, she would be able to determine the procedure of what an investigation entails. Stacey Earhart is not an insurance investigator, and therefore she cannot determine whether or not this investigation was of standard procedure and to the degree of the investigation.
Counsel, let me ask you this. Under Rule 701, a layperson is entitled to give an opinion based upon rationally based perceptions of the events as they occurred. Is that permissible here?
No, Your Honor, this is not permissible here because this witness has not, opposing counsel has not laid any foundation that this witness would have anything to go off of to compare this to any other sort of investigation.
I understand your objection, but I'm going to overrule it and allow the witness to testify based upon Rule 701 of the Rules of Evidence.
Yes, sir.
Yes, Your Honor.
Proceed.
Ms. Earhart, once again, could you please describe how this interview went for us?
Yes, Charlie Yeager started making personal shots at me. I'd never met her before, I didn't know her, but she came in and she told me that she didn't like me. She didn't like what I was doing to the Yeagers' land, which made no sense to me because the land didn't belong to the Yeagers. It belonged to the community. And then she told me that I was no better than that darn DA. She didn't use the word darned, and I had absolutely no idea what she was talking about.
Ms. Earhart, after this interview, did you eventually receive the insurance policy?
Yes, we did. I knew that Charlie Yeager didn't want us to. But we did.
Objection, Your Honor. Speculation.
Okay, counsel.
Your Honor, again, I believe this to be a rationally based perception based on how the interview went with Charlie Yeager, specifically the fact that he didn't like her and was making personal attacks at her.
Your Honor, may I respond?
You may.
This witness just testified that Charlie Yeager didn't want the preserve to receive this rider. That goes directly towards the state of mind of Charlie Yeager. And pursuant to Rule 701, the state of mind cannot be testified to by a lay witness.
Counsel.
Your Honor, I believe in previous testimony by Charlie Yeager herself, she said that she didn't want the preserve to have the insurance policy.
Your Honor, may I respond?
Okay, one more time.
Regardless of whether or not previously in today's trial, Charlie Yeager stated that, Miss Stacey Earhart cannot testify to Charlie Yeager's state of mind in that incident, as there has been no foundation laid that Charlie Yeager specifically told Stacey Earhart at any point that she did not intend for them to receive the rider.
I believe both of you have made very good arguments. It's a very close question, but I'm going to sustain the objection in that it goes more to the state of mind of Charlie Yeager, which has already been testified to, rather than the perception of this witness.
Motion to strike the testimony from the record, Your Honor.
It is so stricken. But I'm not striking what Charlie Yeager said, just what this witness has
Yes,
said.
Your Honor.
Okay, thank you. You may proceed, counsel.
Yes, Your Honor. And Miss Earhart, did you ever get the drone after this interview?
Yes, we did.
And did it serve your purpose of taking videos of the preserve well?
No, it didn't. I realized after I bought the drone that the camera that was on it, it was pretty much a toy. It was not sufficient for my conservational needs. So once again, I petitioned the board to buy a film-grade camera so that I could do my work properly.
And did you get this film-grade camera that you petitioned the board for?
Yes.
Miss Earhart, besides the new camera, did you make any other changes to the drone?
Just a few tiny tweaks here and there. I added a little set of fins and a tiny dog whistle.
Miss Earhart, after you made these slight changes, did you notice any change in the way the drone flew?
To be honest, I really didn't notice much of a change at all, no.
Miss Earhart, on the morning of September 27th, what were you doing?
I was in the fire tower that morning. It was a fox hunt, and I wanted to make sure that no one trespassed into the restricted area.
Were you flying the drone at this time?
Oh, absolutely not.
Well, why was that?
Well, the wind conditions on September 27th were not ideal whatsoever. It was very gusty, unpredictable. I don't like flying the drone in the wind. I'm inexperienced. I just really try to avoid it at all costs.
However, did you fly the drone on September 27th?
Yes, I had to.
Well, what do you mean by that, Miss Earhart?
Well, as I was standing in the fire tower, I noticed a ruckus on the border of the restricted area. And I saw that Stephen Yeager was leading a charge straight towards me in the fire tower, right through the restricted section. He was tearing up plants as he went, destroying all the work that Finley and I had just done. It was completely unbelievable. I could not believe his behavior, and I just had to get it on camera.
Miss Earhart, after you took the drone out, could you describe what happened for us?
Yes. I was flying the drone when all of a sudden a big gust of wind came up from behind it, and I completely lost control. It was at that point that I just dropped the remote and I ran down to see Stephen. It was horrible.
Thank you, Miss Earhart. No further questions, Your Honor.
Is plaintiff ready to cross-examine?
Yes, Your Honor.
You may proceed.
Good afternoon, Miss Earhart. I'd like to start off by asking you a few questions about the modifications you made to the drone. Now, you added fins to the drone, right?
Yes, I did.
And you added the fins to give the drone better control in higher winds, yes?
Yes, that's true.
So we can agree that you added fins specifically to change the way that the drone flew, right?
It was supposed to help it, I guess.
And as you said in your own affidavit, the fins worked great, correct?
Yes, like I said, I'm really inexperienced in the wind. I don't like to fly in the wind at all.
Now, I'd like to talk to you about your altercations that you had with Stephen Yeager. You had gotten into numerous fights with him, right?
Yes, he was not the ideal person to deal with.
The first one was in March of 2013, yes?
That is true.
And that was after Stephen had ruined weeks' worth of work on the preserve.
Yes, and not only weeks' worth of work, but also thousands of dollars that we did not have to spare on the preserve.
Absolutely. You were angry about this, right?
It was extremely frustrating to have your life's work just destroyed.
And it was only a few days after that that you decided to send out an email, correct?
Yes, that is true. I wanted everyone who was a member of the preserve to know what was going on because they deserved to.
Your Honor, may I approach the witness with what has already been marked as, or entered as Exhibit 4?
You may.
Oh, let the record reflect that I am showing opposing counsel the copy that I'll be handing to the witness.
Thank you.
Here, Ms. Earhart. This is the email that you sent out to all of NHP, correct?
Yes, it is.
It's a fair and accurate representation?
Indeed.
So at line 7, you say in that email that you were mandated to tolerate this crime against nature, right? Line 7 in the first paragraph. And then on the second page, line 4, you say that you believed a better tactic is an eye for an eye, right?
Yes, but for me, later on, I say that I use my words. I'm a pacifist.
Well, and then at the very last line, or the second to last line, you say that if your voice isn't heard, then your actions would be felt, yes?
Exactly. I was using my words in this email to gain support from our members because I wanted them to know what was happening.
Well, the next action you took was to request a drone to your board, right?
Yes, that was for the conservational work of monitoring our plant growth.
And you were given the power to use this drone by the board, right?
Yes, I was. I'm very grateful.
But with that power came responsibilities within a rider granted you by Lilienthal, yes?
They had certain requirements, yes.
And we can agree that nowhere in that rider did it say that you could use the drone to monitor individuals, correct?
Absolutely, and I never intended to.
Well, Miss Earhart, on March of 2014, you specifically used the drone to monitor the location of the Hunt Club, yes?
Yes, they told me where they were going, so I knew.
And you wanted to catch them in the act, right?
That was in case they came into the restricted section.
And then another incident happened in June of 2014, correct?
Yes, that was once again for, I believe, the third time when Stephen entered into the restricted area, even when I told him not to.
Exactly, and it was at this time that you threatened him, correct?
I threatened to take legal action just because I wanted him to know that this was very serious.
But Miss Earhart, you yourself said you knew you wouldn't get anything legal out of it, right?
No, I just wanted him to know that this was very serious, and I was serious about it as well.
Well, Miss Earhart, exactly. You said that your threat was real, right?
Absolutely. I wanted him to know that he was breaking the contract that he had with the preserve.
You wanted to show him who was boss, right?
Exactly. I'm the land manager of the preserve, and in that job position, I'm in charge of protecting the land. That is my job.
You wanted to scare him, yes?
I would put the fear of God in him, yes.
And then on September 27th, just 3 months later, Stephen once again came onto restricted area, right?
Yes, it was unbelievable.
And you took the drone out for a first pass, right?
Yes, I did, but unfortunately, I just couldn't get any pictures.
That's right, so you took a second pass.
Yes.
And this pass you took consciously with the conscious objective of getting closer to Stephen, correct?
I got lower because, like I said, I couldn't get a picture through the tree cover.
So, Miss Earhart, that's a yes to my question. You flew the drone on the second pass with the conscious objective of getting the drone closer to him. Yes or no?
Yes, I had to get a lower altitude.
Thank you. Your Honor, no further questions.
Is there any redirect examination of this witness?
Briefly, Your Honor.
You may proceed.
Ms. Earhart, to your knowledge, was flying this drone close to the Hunt Club in violation of that insurance policy?
Oh, absolutely not.
Objection, Your Honor, outside the scope of cross-examination.
Also, counsel.
Your Honor, I was not asking this witness whether or not her flying the drone over Stephen Yeager was a violation of the rider. And furthermore, Your Honor, it's irrelevant.
Counsel?
Your Honor, I believe that one of the claims the plaintiff is making today is that the fact that this drone was flown close to the Hunt Club violated the insurance contract. I'm showing that Ms. Earhart had full knowledge that flying the drone close, even under the insurance contract, was not a direct violation.
Your Honor, may I respond?
You may respond.
That is not at all what the plaintiff is contending with that testimony. That testimony simply went to Ms. Earhart's intent. It had nothing to do with the rider and the subsection as to whether or not Stacey Earhart could fly the drone over people. Therefore, this question is outside the scope of my cross-examination.
I don't perceive it as such, counsel. It's an issue you raised on cross-examination, and it is also an issue germane to the decision in this case, and as such, I don't believe it's beyond the scope of cross, and I'm going to allow the questions.
Yes.
Once again, Ms. Earhart, was flying this drone close to the Hunt Club, to your knowledge, in direct violation of this contract?
Absolutely not. The rider that I got says that I can't fly it directly over anyone, which I never did.
Thank you. No further questions, Your Honor.
Any recross?
No recross, Your Honor.
Okay. The witness can step down. And does the defense have any other witnesses?
Yes, Your Honor.
Okay.
At this time, the defense calls Captain Emery Wagstaff to the stand.
All right. The witness is under oath. and we'll just follow the directives that I've given to the other witnesses.
Yes, Your Honor.
You
May I
can
proceed?
Counsel.
Could you please state your name for the court?
Captain Emery Wagstaff.
What is your occupation, Captain Wagstaff?
I'm an aeronautical engineer, and I own my own consulting firm that serves small civilian drone users. But before that, I served our country. I was in the military.
Do you have any prior experience with drones?
I actually have more experience than anyone. I invented the first drone, the RQ-11 Raven.
Could you please explain?
I was in the military a number of years ago, and a fellow soldier needed a device for surveillance. So I essentially hooked up the first prototype of the drone, and after that, the Pentagon was so interested that they sent me there to develop the whole program.
After your time in the military, did you continue work with drones?
I did. I actually consulted with Amazon. I would help them design different types of drones that could carry different goods to their customers.
And have you ever testified in court before regarding drone use?
I have, and I've also testified before Congress and the Federal Aviation Administration, or the FAA.
And could you please describe your educational background for the jury?
Certainly. I received my bachelor's at West Point with high honors, and then I mastered in aeronautical engineering.
Your Honor, at this time, the defense asks that Captain Emery Wagstaff be recognized as an expert in the field of aeronautical engineering.
Plaintiff?
No objection, Your Honor.
The witness will be so recognized as an expert in that area. You can proceed.
Yes, Your Honor. Could you please describe how you prepared for the proceedings in court today?
I made my own investigation, which included reading all of the witness statements, reviewing the blueprints of the drone, speaking with Stacey Earhart, and reviewing Miss Val Coleman's report.
What was found in Miss Val Coleman's report?
Val Coleman essentially found debris. After the drone had crashed, it was in pieces, and that's what she found.
Are you aware of any conclusions Miss Coleman reached after finding this debris?
Yeah, somehow Val Coleman concluded that in all of this wreckage, she could make out that there were material modifications.
Do you agree with this conclusion?
I do not know. I understand through my review of the testimony that there were slight changes made to the drone, but nothing that would constitute a material modification.
Well, Captain Wagstaff, what is a material modification?
Oh, a material modification is anything that would change the way the drone flies or how it handles.
So what changes were made to this drone and present when it crashed?
All of the witnesses collectively agree that there was a camera, a set of fins, and a whistle added to the drone.
And the camera, why was that not an issue when it was added?
It's not an issue because this drone is a quadcopter. You see, a quadcopter has 4 propellers, 2 in the front and 2 in the back. It generates lift from the propellers and is therefore very stable and easy to withstand slight changes. This new camera was only 3 pounds heavier than the old one.
And was the drone stable enough to withstand the other changes, the whistle and fins?
Most definitely. All these modifications did was make noise. They're not going to change the way a quadcopter flies.
So, Captain Wagstaff, if these changes did not affect how the drone flew, in your expert opinion, why did the drone crash on September 27th?
There's really only one answer, and that's poor piloting. I understand that Stacey Earhart is not the most experienced pilot, and I also read that the conditions that day were not ideal. And it's also very possible that nervous pilots can tend to jerk the controls, so Stacey Earhart really was inexperienced and accidentally crashed the drone.
Thank you. No further questions, Your Honor.
Is the plaintiff prepared to cross-examine?
Yes, Your Honor.
You may proceed.
Captain, you have an agenda in testifying here today, don't you?
Absolutely. My agenda is to give the truth.
That's not the only reason you're here, Captain. You're also here to explain why we don't need more rules for drones.
Yes, and my findings in the investigation.
Now, you've been paid $20,000 for your investigation and time for today's case, right?
Yes, from two separate sources.
Half of that $20,000 was paid by the defendant, the Natural Habitat Preserve, correct?
Yes, that's my going rate.
And Captain, the other half was paid by the legal fund of the Drone Pilots Association. Isn't that true?
It was. It's a fine organization. That's just one of the perks. If I testify, I can get paid for it.
The Drone Pilots Association is an organization devoted to the expansion of less regulated drone aviation, right?
Yeah, absolutely.
So, Captain, to be clear, we're talking about an outside organization with an agenda paying half of your enumeration to testify here today?
Yes, their legal fund provides services if I ever had to testify, and they did in this case.
Next, let's talk about your investigation. Now, on direct examination, you offered an opinion about why the drone crashed, didn't you?
I did.
But, Captain, you're not a crash investigator, are you?
No, I don't need to be.
You've never investigated a plane crash?
No, I haven't. This wasn't an airplane. This was a drone.
Helicopter crash, Captain?
No, this was a quadcopter, not a helicopter.
Well, you've never investigated a drone crash either.
No, like you said, I'm not an aircraft crash investigator. I'm an aeronautical engineer.
You've never investigated any type of crash, have you?
No, I don't need to. I was just drawing my conclusions from what I read.
And finally, let's talk about material modifications. Now, Stacey Earhart added fins to the drone, did she not?
She added them at one point, but after a certain time, they were removed.
Well, you don't know that, do you?
Yes, I do. I read her statement, and she says she took them off.
Stacey Earhart says she took them off, but no other witness corroborates that.
Well, Stacey was the only one who piloted the drone. I'm not sure how anyone else would know that they were taken off.
Finley Lindbergh was there on the day in question.
Yes, but Finley is not a pilot.
And you reviewed Finley Lindbergh's affidavit, didn't you?
I did.
So you're aware that Finley Lindbergh says the drone looked exactly the same as it had all summer, right?
Yes, but that's a very vague statement. I'm not exactly sure what that means.
And Captain, you weren't there on the day in question, were you?
No, I wasn't.
So you didn't see whether the fins were on or off, right?
No, and neither did Val Coleman.
But regardless, on direct examination, you said that the fins would just make some noise. That's what you said?
I read through the statements, and it was agreed that they were whistle fins.
No, Captain, there were two separate modifications. One was a whistle, and the other was fins, right?
Yes, there was a whistle added to the drone and a set of fins that would make noise.
Now, in your affidavit, you have a different opinion. You actually say that adding fins is serious business, correct?
It can be.
Because modifications like fins can cause serious issues with airworthiness, right?
It's possible, but I saw the blueprints, and I don't believe these fins were an issue.
And they can especially cause issues if they hadn't been tested in high winds. Isn't that correct?
Yes, and unfortunately, Stacey didn't test them in high winds, but they were taken off that day.
That's right, Captain. Well, once again, Captain, we just established you don't know whether they were on or off, right? You weren't there.
I wasn't there, but I know she took them off.
You don't know that she took them off because you weren't there, and no other witness except for Stacey Earhart corroborates that. Did you just testify that?
Objection, Your Honor. This is argumentative.
Counsel?
Your Honor, previously I asked the witness whether Stacey Earhart was the only witness who testified that the fins were taken off. I then asked the witness whether Finley Lindbergh said that they were taken off, and Captain Wagstaff agreed that in Finley Lindbergh's affidavit, she states the drone looks exactly the same. I then further questioned the witness whether she was there or not, and eventually the witness admitted that she doesn't actually know whether the fins were on or off. Now, later in my line of questioning, Captain Wagstaff began to contradict herself and said that she knows the fins were on.
Well, counsel, I just want to caution you, it's for the jury to determine whether she contradicted herself as
Yes, Your
opposed to you, but you go ahead.
I just wanted to clarify for the jury that Captain Wagstaff doesn't actually know whether the fins were on or off on the day in question.
Counsel?
Your Honor, I believe that opposing counsel made references to previous statements of the witness and is trying to make an argument in this case, and this would be an argumentative question.
Well, I'm going to overrule your objection and allow him one more crack at it, but I believe the witness has already actually answered the question.
Yes, Your Honor.
So you go ahead.
So, Captain, just to be clear, modifications like fins can create real issues if they hadn't been tested in high winds. Stacey Earhart, to the best of your knowledge, never tested those fins in high winds, right?
No, unfortunately, that's pilot negligence.
And on the day in question, there were high winds, weren't there?
Yes, she lost control of the drone, but the fins weren't on there.
Nothing further, Your Honor.
Is there any redirect examination of this witness?
Briefly, Your Honor.
You may proceed.
Captain Wagstaff, does it matter whether or not the fins were present on the drone in the day in question?
I don't think it particularly matters, no. I don't believe they were on there that day, but at the same time, the heavy winds would have made Stacy lose control regardless. And she could have been nervous too, and that's another reason why she could have lost control.
And on what basis of experience do you make the claim that nervous pilots can lose control of drones?
Oh, I completely agree with Val Coleman. Val Coleman says that novice pilots can often jerk the controls, and I completely agree with that statement.
And do you have any other of your own experience that would lead you to this conclusion from your work with drones?
Absolutely. I've worked with drones longer than anyone, and I've seen all different types of pilots pilot drones, and I've seen that happen myself.
And can you please explain exactly what the wind conditions were on the day in question?
Oh, the wind was very unpredictable that day. From what I understand, a gust just came out of nowhere, and Stacy lost control.
Would gusting winds irregularly necessarily qualify as high winds?
Absolutely, or sometimes, it depends.
Thank you. No further questions, Your Honor.
Any recross examination?
Briefly, Your Honor. On redirect examination, you testified that it's possible that Stacy Earhart simply lost control of the drone since she was nervous, right?
Absolutely.
But we can also agree that it's possible Stacy Earhart lost control of the drone because if the fins were on, then they would have malfunctioned in high winds, considering she didn't test them in high winds, right?
Absolutely. The wind was very unpredictable, and Stacy should have tested them, but she didn't, and that's just negligence.
Nothing further, Your Honor.
The witness can step down.
Yes, Your Honor.
Does the defense have any other witnesses?
No, Your Honor. At this time, the defense rests.
Okay. Is the jury ready for closing arguments? Okay, we've reached a point in the case where the parties are entitled to give their closing arguments. Because the plaintiff has the burden of proof, the plaintiff will close last, and we will begin with a closing argument by the defendant.
Yes, Your Honor. May it please the court?
You may proceed.
Opposing counsel. Ladies and gentlemen of the jury, insurance companies have a great power. They have the power to forgive mistakes in the case of an accident or tragedy. But with that power that's held by insurance companies, they also have a great responsibility. The responsibility to ensure that their insurance agreements are clear and easy to understand on the part of their policyholders. The responsibility to ensure that whenever there's misconceptions or misunderstandings with this policy, that those be cleared up. And most importantly, insurance companies have the responsibility to indemnify their policyholders when they follow the letter of the contract as it is written. Lilienthal Insurance is arguing today that their policy was breached, but keep in mind that they must show you that the actual letter of the insurance policy has been violated. Now, the actual letter of this policy, the actual words on the paper, are incredibly vague, ladies and gentlemen. And it is on those vague aspects that are open to interpretation that the plaintiff has been claiming that the insurance policy was breached. How can the Natural Habitat Preserve be expected to follow this insurance policy of Lilienthal's interpretation when their own insurance officer said she did not clearly understand the policy? There was no way for the Natural Habitat Preserve to clearly understand it as Lilienthal intended, and therefore they had to follow it as it was written. Now, the first written point of this insurance contract that the plaintiff claims was breached was material modifications. Now, keep in mind that Charlie Yeager didn't understand what a material modification was, and neither did the Natural Habitat Preserve. Luckily, material modification has been defined by the court. But with that definition of one that would significantly impact the flight of the drone, the Natural Habitat Preserve did not violate their policy. You heard that small and unimportant changes were made, and the plaintiff has offered no evidence that there were material modifications on that drone. and their own expert witness said she could not identify any of these material modifications in the wreckage. Instead, you heard that they did not have a significant impact on the drone and that when Stacey Earhart flew this drone after the modifications were made, she did not notice a difference. Those would be small and insignificant changes and not a material modification. Their own expert witness also said that she is scientifically uncertain about the weight of the drone. And the only person who weighed the drone, Quincy Wright, stated it was under 55 pounds. So Lilienthal Insurance has also asserted that the drone was used improperly. Now, by used improperly, they must prove that the use went against the insurance policy. Time and time again, they have stated that it was flown too close to Stephen Yeager, near the Hunt Club. But that is not an aspect of the insurance agreement. The insurance agreement says that you may not fly the drone directly over individuals. It was the Natural Habitat Preserve's understanding that that was how they were to follow the policy. And when there was a complaint made to the Natural Habitat Preserve about their use of the drone, that it was flown too close to the Hunt Club, how did Lilienthal Insurance respond? They told the Natural Habitat Preserve that they were in compliance with the policy. That was when Stacey Earhart was flying it over the restricted section on March 22nd, when the Hunt Club alleged that it was flown too close to them. And the Lilienthal Insurance even stated they were always allowed to fly it in the restricted section. So on September 27th, when Stacey Earhart was flying it near the Hunt Club in the restricted section, the Natural Habitat Preserve had to have believed that this was in compliance with the policy, as it's what Lilienthal Insurance led them to believe was the interpretation of the policy. Now, the drone may only be used for purposes involving conservation and education. But again, conservation was not defined. So Stacey Earhart interpreted that to mean if she could use her drone to protect a restricted section by getting evidence that they were trespassing on the preserve and damaging her conservational work and getting them removed legally, that would be a conservational effort. And at no time did Lilienthal make clear that this was against the insurance policy. Unfortunately, Stacey Earhart lost control of the drone while she was trying to use the drone for conservational purposes. You heard a gust of wind took it out of her control. And because Stacey Earhart was merely negligent when she flew the drone, because she could not clearly interpret it how Lilienthal wanted it interpreted, and because it was followed to the actual letter of the law in the insurance agreement, I ask you to hold Lilienthal Insurance to their great responsibility and pay for the compensation of Stephen Yeager. Thank you.
All right, is the plaintiff ready to close?
Yes.
You may proceed.
With great power comes great responsibility. But when you abuse the power you're given, you must accept the consequences. May it please the court, opposing counsel, members of the jury. What happened to Stephen Yeager is a tragedy. After being paralyzed from the waist down, he will never walk again. He will never have children. His life is forever changed. Now, Stephen will receive $2.5 million for his injuries, but the question at hand is whether or not Lilienthal Insurance must indemnify or pay for the preserve settlement. Now, as plaintiff, we bear the burden of proof, meaning we had to prove by preponderance of the evidence, meaning more likely than not, only one of three things: that Stacey Earhart had intent, made material modifications, or added excess weight. And we have met our burden. First, Stacey Earhart had intent. As you saw on the stand today, Stacey Earhart became enraged when asked about Stephen Yeager. It was after the first incident in March of 2013 when Stephen entered restricted area that Stacey sent out an email demanding an eye for an eye. And it was just 1 week after the preserve had been vandalized by a member of the Hunt Club. 1 week after Stacey knelt on the ground, pounding her fists and screaming for revenge, that she requested to purchase a drone to monitor the Hunt Club, to use it as high-tech border patrol. Now, in order to prove intent, we had to prove that Stacey Earhart intended to scare Stephen Yeager. And members of the jury, Stacey Earhart took the stand today and told you that she wanted to put the fear of God into Stephen. If that isn't intent, then members of the jury, what is? The defense tried to tell you that Stacey lost control of the drone, but she didn't lose control of the drone. She lost control of her emotions. Second, Stacey made material modifications. The court has defined a material modification as anything that could affect the airworthiness or the ability to fly of an aircraft. Now, as plaintiff, we don't need to prove that Stacey Earhart knew of this definition. All we need to prove is that Stacey Earhart, by definition of the court, did in fact make material modifications. Now, as Val Coleman, an expert in aeronautics and accident reconstruction, told you, Stacey Earhart made material modifications when adding the fins and the whistles. And Finley Lindbergh told you that both the fins and the whistles were present on the drone on the day in question. Stacey Earhart herself admitted to you today that she added fins specifically to change the way the drone flew. And that, members of the jury, is by definition a material modification, directly violating the rider. Third, Stacey added excess weight. Today's case is about a drone crash. Now, you heard from 2 experts today, but only Val Coleman is an expert in accident reconstruction. And only Val Coleman can tell you with a degree of scientific certainty how much the drone weighed on the day in question. She told you that after applying an 80% rule, an industry-wide standard, she was able to determine that the drone weighed more than 55 pounds. With every addition Stacey Earhart made, she overstepped the boundaries of power she was given, voiding the rider. Now, with great power comes great responsibility. And Lilienthal gave Stacey Earhart and gave the preserve the power to use the drone to make the world a better place. But as Stacey Earhart told you herself, that isn't what she used it for. In using the drone to scare Stephen Yeager, in making material modifications, in adding excess weight, Stacey Earhart ignored her responsibilities that were within the rider. She didn't hold up her end of the bargain. And that is why we ask that you do the right thing. You do the just thing. Find in favor of the plaintiff. Thank you.
Members of the jury, you can finalize your sheets, and you can retire if you desire to make your decisions. Before everyone sits down, let's give all of these children a round of applause. Be seated for a minute. These matches never cease to amaze me. This is my 26th year being involved in mock trial. I have been a juror, I have been a teacher advisor, I have been a timekeeper, and I have now been a judge for 3 years in both our local competition and now this honor today. I can tell you that this is one of the finest matches I've ever observed, and no matter who comes out on top in this, all of you are winners. You did splendidly, and I can't praise you enough for your work. I can tell you that in my county, we had our county championship last year, and one of our court administrative staff came up with the idea of trying to find people who came through our program who are now lawyers to sit on the jury for our county final. And we were wondering whether we could have enough people to comprise a jury. And after studying it, we found out we had over 20 students who had come through our program who are now lawyers. And they are not only lawyers, but they are partners in firms such as Jones Day, Reed Smith, Sean McClay, and a number of other teams. That should be some inspiration to all of you, because this program is not only important for now, but it will be important for your futures. I always say this, I look back on my high school days, and if I had to write a paper or give a talk in front of my classmates, I was afraid and embarrassed to get up in front of my own class, let alone a room full of people such as this. And for you to be able to get up today and do what you did is just astonishing to me. I can tell you, first of all, that your understanding of the facts and the rules of evidence here is far superior to many of the lawyers that I face on a daily basis, and for that you should be commended. More important for the people in the audience, so you know, an insurance coverage case is not easy. This is essentially a subrogation matter, and whether there is insurance coverage. Most lawyers shy away from taking these cases because they are complicated. And you took on a case that would be complicated for lawyers, broke it down, and tried to make it simple for a jury to understand, and you did a wonderful job. I really wish you well in whatever endeavors you choose in your life, and I hope that maybe we'll get a lawyer or two out of this crowd. If we do, that in itself will be my satisfaction from what I did today. Are there any matters that any of the lawyers would like to ask me or like to say in conjunction with today? If so, we'll take time for that. Anything?
Thank you for taking the time to chat us today.
This was, thank you. This was wonderful. And I don't know, do they give awards at this level like they do at the county for best witness and best advocate? Okay, why don't you take the time to fill out your sheets?
People, community, neighborhoods. PCN, Pennsylvania's neighborhood.
Could I have your attention? Before the jury comes back, it may be appropriate if we would make the awards for the best advocate and the best witness for each side. So at this time, I will recognize the plaintiff side to make their award to the defendant for best witness and best advocate.
For best advocate, we have Thomas Belsterling. And then for best witness, Grant Burnett.
For best advocate, we have Samara Kasai. And for best witness, Kobe Watts.
Congratulations to all. It'll probably be just a few minutes and we'll have the decision of the jury. So you can go back to talking if you desire.
The Pennsylvania Supreme Court on PCN. Check PCNTV.com for listings. PCN, Pennsylvania's neighborhood.
Has the jury reached a decision in this case?
We have, Your Honor.
Would the foreperson please announce the verdict?
As elected foreperson, this being my 30th year participating with this, and my final year, I have the privilege of announcing the verdict for the defense.
The Pennsylvania Mock Trial Competition is being brought to you by the Pennsylvania Bar Association, which strives to promote justice, professional excellence, and respect for the law, improve public understanding of the legal system, and provide access to legal services for all citizens. And by the Pennsylvania Bar Foundation, representing the commitment of Pennsylvania lawyers to promote youth justice education and to ensure equal access to the law for Pennsylvania's most vulnerable.